All right, good morning, everybody. My name is Megan Glowacki. I'm a partner in our labor and employment practice group here at Thompson Hine. I want to welcome everybody to today's in-person and webinar program. As I mentioned, it's being hosted both virtually and here at our Thompson Hine offices. For those who are participating on the webinar seeking CLE credit, CLE codes will be shared throughout the presentation, which will need to be recorded on your affirmation form. This form can be found in the handout section of the GoToWebinar control panel on the right-hand side of your screen. Please click and download that form now. I will also repeat the CLE codes at the close of the program just to recap. For those attending in person, please remember to sign in and out appropriately on the forms in the lobby. We have a great lineup of speakers today. We're going to be providing an update on various employment issues, COVID-19, of course, things you might have missed while you were worried about COVID-19, the new world of trade secrets, and thereon. So due to the large audience, both on this call and in person, and the amount of content we're presenting, we may only have a short time for question and answers. We encourage you to put your questions in the chat box, and we'll try to address them with the time we have remaining. But we certainly encourage you to contact your Thompson Hine lawyer with any follow-up questions you might have after today's webinar. To proactively answer a question we receive frequently, we will be recording today's webinar, and the recording will be available to all registrants within the next 2 business days. So thank you, everybody, for your interest, and let's kick off today's program. I'm actually going to start off with my colleague, Beth Mandel. We're going to be talking about what else? COVID-19, the thing everybody continues to talk about. And I will tell you that if I was here last year, I would have been saying, Megan, if you're still talking about COVID-19 in the winter of 2021, we've got a real pandemic on our hands. And well, of course, here we are. And I say to myself, hopefully we're not going to be talking about COVID-19 this time in 2022, but I guess that remains to be seen. So for our agenda this morning, we're going to talk about the current state of affairs. We're going to recap on the OSHA ETS, and then Beth is going to talk about benefits considerations with respect to COVID-19. So what is the current state of affairs? I had a number of word choices I could have used here: whiplash, draining, chaos seems about the only appropriate one. And we've got a host of issues that employers are trying to grapple with. The federal contractor COVID-19 vaccine requirement, the OSHA ETS for large employers, coupled with state bans on COVID-19 vaccine mandates, basically the attempt by certain states to counteract the OSHA ETS and the federal contractor requirements. And then counter to that, we now have just this week local vaccine mandates popping up. So New York City is our first local jurisdiction to announce that they will require businesses of all sizes to require the vaccine for their employees. So not a ban, the exact opposite, further than the ETS. If you are an employer, a private employer in New York City, if this particular piece of governance goes into place, and it's yet to be seen, we expect guidance on the 15th next week about what does this mean, what are the actual requirements. We assume that there will be exemptions for religious and medical reasons, but we don't really know much of the details besides Mayor de Blasio's announcement that all private employers must require employees to be vaccinated against COVID-19. To be seen whether New York is the tipping point and we have other sort of local jurisdictions. I'm already thinking of our San Franciscos and of our Seattles and whether they decide that they too are going to follow suit. But in short, we have a bunch of things all over the place that we're trying to keep in touch with. So let's first start with the federal contractor requirements. under the executive order issued by President Biden, certain federal contractors and subcontractors must mandate the COVID-19 vaccine. Unfortunately for the folks in the office here, our materials were prepared, printed yesterday before that federal contractor executive order was stayed nationwide by a federal court in Georgia. So originally we had Ohio, Kentucky, and Tennessee who were exempted from the order due to a judicial ruling by a Kentucky federal court judge. Just yesterday, we had a federal court judge in Georgia go even further and stay or enjoin that contractor mandate nationwide. The OSHA ETS for private employers was stayed by the Fifth Circuit, but is currently under review by the Sixth Circuit. We'll get into that morass in a moment. And then we have these states implementing laws designed to prevent local governments, schools, and private employers from mandating that employees receive the vaccine. We've got a lot of states who are percolating with these types of issues, including Ohio. There certainly have been bills moving its way through the legislature on this point, though none passed yet. States like Montana, Tennessee, Florida, to a smaller extent Alabama and Iowa, they've already passed these mandates. So what this means is compliance chaos, compliance confusion. What do I do if I am a federal contractor with more than 100 employees who have employees located in Florida or Texas, where the states are telling me you can't require the vaccine, and the executive order or the OSHA ETS were telling me I do? Well, we would recommend you call us. We had to kind of go through the judicial legal preemption analysis. What does the state law say versus what does the federal contractor requirements require? And is there a way that you can comply with the federal contractor compliance and the state law? Are federal preemption guidelines going to overrule the state bans? Right now, this isn't an issue anymore. We have a stay, as I mentioned, on the federal contractor executive order. But those orders are going to be subject to judicial review in the Sixth Circuit and the 11th Circuit. Not great circuits for the Biden administration to be in, candidly, but ultimately there will be Supreme Court review, and it's possible that the federal contractor or the OSHA ETS will go into effect. So keep these issues in mind. Now, if you are a federal contractor that also has more than 100 employees, you're subject to 2 vaccine mandates should they go into effect, but they have different requirements. And I'll talk about it in a minute, but in essence, the federal contractor mandate has no testing exemption. It does not allow employers to choose to test employees weekly if they're unvaccinated. The OSHA ETS does. If you're in this wonky land, you probably need to be following the stricter federal contractor guidance so long as your employees are actually covered by that executive order. And of course, now I need to say constantly when and if it goes into place. And then as to an overlap, if you're not a federal contractor, let's say the OSHA ETS does go into place and you have employees in Florida, Texas, other states where they may try to ban vaccine mandates. The OSHA ETS clearly in its language takes the position that it preempts state and local bans. That's, of course, OSHA's view. You would need to analyze your compliance requirements under whether we do or don't have preemption, and whether based on the state law, there's a way where you could be in compliance with both. So this compliance confusion had, until yesterday, was a lot more murky. Right now we know none of the ETS, none of the contractor requirements are in place nationwide, but the state bans are. So you don't have to go through this analysis unless you're an employer who has voluntarily implemented a vaccine mandate, in which case you certainly do need to be aware of the state requirements in which your employees work. So let's dive into the federal contractor executive order a little bit more. And the one caution that I give to everybody is please don't assume that just because one district court judge has issued an injunction, even in a nationwide scope, that this is dead in the water. Even if we're in a bad jurisdiction for the Biden administration, it doesn't mean that these executive orders won't go into place once we've gone through the totality of the judicial review. So the federal contractor executive order applies to federal contracts for services and or construction which are entered into on or after October 15th or renewed or extended on or after that date. Okay, so if you've been a federal contractor in the past, you have a federal contract that's dated June 1, 2020. It has not yet been extended or renewed and you don't have a new contract with the government. Or let's say you're a subcontractor and you don't have a new purchase order extension from your prime contractor. You would not be subject to the executive order until you get that contract indicating that you are subject to the mandate. So just because you're a federal contractor doesn't mean automatically you are subject to the vaccine requirements. It does impose the vaccine mandate as well as other safety protocols set forth by what the Biden administration put together as this Safer Federal Workforce Task Force. So don't take a myopic view of this issue. It is not just vaccine mandates. You need to be aware of other masking and health and safety requirements. Most importantly, to distinguish from the OSHA ETS, as I previewed for you, there's no testing alternative. There are religious and medical exemptions, but there is no option for an employer to say, I don't want to go this far. I don't want to force my employees to get vaccinated, so I will allow them to test. Under the federal contractor rules, they have to test. There's no opt-out there. And I guess what I would say is when the federal judges in Kentucky and in Georgia looked at the executive order, they overruled it on the basis that the Biden administration and federal contracts are about procurement. They're not about health and safety. And basically saying it goes too far to require contractors to mandate a vaccine versus the administration processes of a federal contract. And so, you know, does that argument have some merit or some weight to it? I certainly think it does, mainly because I don't think ever before we've had a process where a federal contractor was requiring a certain medical exam or requiring sort of a medical injection, if you will. That being said, you don't have to be a federal contractor. You as an employer could opt out of that business. So we'll see how the courts ultimately rule on this. I suspect that the injunction will probably be upheld in the very sort of business-friendly 11th Circuit Court of Appeals. But it is possible, probably more than the OSHA ETS, just in my humble opinion, that the federal contractor order gets through, even if the OSHA ETS does not. So as I mentioned here, the vaccination is mandatory for covered contractor employees who work on covered federal contracts or subcontracts, who work in connection with covered federal contracts or subcontracts, or work at a location where employees in either of the first two options are likely to be present. Now, if you're a federal contractor, you have a direct contract with the government, you know it. You are subject to a plethora of federal requirements, under non-COVID times. Many of our clients, though, have come to us and said, I don't know, I'm a subcontractor. I think I'm part of the flow down chain to the government. Or maybe I have vendors who are federal contractors. Ultimately, maybe my goods or services get into the hands of federal employees. Again, what I would reiterate is unless your client or customer has provided you the written notice that they are subject to the executive order and now have a contract that requires employees and subcontractors to be vaccinated, you are not subject to the executive order. Now, you could certainly go out and do some active due diligence on this. Talk to your contractors if you truly believe, look, we produce goods that I know are ending up in the hands of our military personnel or things like that. But it's also fair to sort of take the view that we have no compliance obligations until and if we receive that contract in that language. Prior to being stayed, there was a deadline of January 18th for full vaccination, subject to reasonable accommodations. So as you can see, I had to quickly add in here, this is stayed by the federal courts now nationwide. Transitioning to the OSHA ETS, the Emergency Temporary Standard, which probably applies to a much broader group of employers, impacting large employers, those with 100 or more employees. And I just want to pause here and say, throughout the various litigations that I've mentioned, and even in some of the sort of preamble text to the ETS, OSHA made very clear that this emergency temporary standard is a stepwise program. That yes, it currently applies to employers with 100 or more employees, but that very shortly it would start applying the ETS to smaller employers as well. So if you have less than 100 employees, do not think you are simply off the hook. It is very likely that if the OSHA ETS is upheld by the courts, that the Biden administration will roll this out to employers. I think when they say stepwise fashion, it's likely that they would next go to employers with 50 or more employees, perhaps then to even smaller businesses. But they have been very transparent that this is coming to smaller employers should it be upheld. So right now, just our large employers either can require employees to be vaccinated against COVID-19 or, and that's a big or, an employer option or allow unvaccinated employees to test for COVID-19 weekly and wear masks in the workplace. Now, most provisions of the ETS were supposed to be enforced starting this past Monday on December 6th, with the enforcement of the testing requirements, the weekly testing requirements, effective January 4th. Taking a step back, earlier last month, the OSHA ETS was stayed by the Fifth Circuit, effectively pausing implementation nationwide. And as I said before, and I completely understand, the reaction after the Fifth Circuit from most of my clients was, thank goodness, good night, I'll see you later. We're never talking about this again. I had my 4 weeks of headache and confusion and craziness. I'm done. Move on. It's end of year. We got a lot to do. I want to put this behind me. And as a labor and employment defense attorney, I've become very good at making sure that you remember the nightmares that you should be worried about at night. And the OSHA ETS is one of those. It is not good night, goodbye, see you later. The Fifth Circuit, I'm calling this an intentional rocket docket. What happened was we had 34 petitions filed nationwide, either objecting to the ETS because they felt like it was way too much, not enforceable against employers. We had petitions from unions and other trade groups who filed saying that the ETS did not go far enough. But regardless, 34 petitions across the country that said the ETS was unenforceable for various reasons. The Fifth Circuit was aware, clearly understood what was happening, was that because various petitions had been filed across 11 different circuit courts, that the judicial panel on multi-district litigation was going to hold a lottery in order to determine which circuit would ultimately decide this ETS stays or goes. So when the Fifth Circuit made their ruling, they intentionally did so before that lottery pick, knowing that it could have an impact on, nationwide play, perhaps trying to influence how the circuit that ultimately received the consolidated hearings would view it. In 3 days, the Fifth Circuit received its petition, reviewed it, briefed it, issued a ruling. Comparing that to what the Sixth Circuit has been doing, and granted the Sixth Circuit is dealing with 34 different petitioners on these consolidated cases, the Fifth Circuit, it sort of intentionally did this at a very fast pace. The Sixth Circuit, after that multi-judicial panel ruling, sort of lottery came out that the Sixth Circuit would hear things, has been taking its time, to put it nicely. This isn't unexpected. Here in Ohio, we deal with the Sixth Circuit all the time. And although the Sixth Circuit is very conservative for the most part, and in fact, as we've looked at some of their pandemic era rulings, I would say they're very conservative on the issue of how much the government can force on private employers. Certainly have not reviewed this type of issue for us to have good clarity about how they will rule. But they've been very don't tread on me, if you will, with respect to various religious petitions that occurred during the course of the pandemic. But no matter how the Sixth Circuit rules or views, what we did know was that they would go through the judicial process, that they were not going to do this via political rulings or means, that they're seeing every filing that comes in, ruling on appropriate motions, where the parties have asked for reasonable extensions of time to respond to a motion, they've granted it. They are not, for better or for worse, for employers, they're not going through their judicial process with our issues in mind. They're going through it from the vantage point of, we have cases before us, how should we rule appropriately on these cases? What that means is we're not going to hear anything sort of quickly. I'll get to it in just a second, but the Sixth Circuit will, in short order, decide what happens to the Fifth Circuit's ruling. And that's really the first decision that will impact us one way or the other. The substance of whether the OSHA ETS stays or goes in total is probably much later down the line. But some of the petitioner requests have been very clear about what their legal theories are with respect to the ETS. And a number of my clients ask, like, what is the basis? What is the legal argument for why the ETS should not be in place? And keep in mind, when you have 34 different petitions from 34 different companies, groups, attorneys general, you get 34 different viewpoints on this. There's not been a lot of coordination amongst the petitioners as to what their legal theories or arguments are, but some of the concurring ones have been that the ETS does not actually address a grave danger, which is the standard by which OSHA has to measure whether or not it can put into place these restrictions. In essence, that COVID-19 is not a grave danger in the workplace. That COVID isn't the type of substance, agent, or hazard that would support the issuance of an ETS, meaning that OSHA deals with things like respiratory issues in the workplace, chemicals, how we view or treat different workplace hazards. COVID-19 is a virus. It is not there is no real clear analogy to how OSHA has handled viruses in the past. Some folks have argued the ETS simply isn't necessary. I will tell you, maybe in June or July, that kind of argument had more flavor, had a bit more oomph to it. As we see cases tick up here in various parts of the country, as we get into the winter months, I'm not sure that that argument holds as much merit to it. There was no process allowing public comment on the rule has been argued, and then finally that the power to compel vaccination rests with the states, not with the federal government. And so, as I said, we're sort of at this tipping point with the Sixth Circuit and how it will decide to rule. And there are kind of different if-then statements that we could try to anticipate what's happening. So the Sixth Circuit, yesterday was the last day for certain response petitions to be filed. On the 10th, this Friday, is the final day of briefing on the issue of whether the Fifth Circuit should be stayed, meaning currently put in place and remain, or during the pendency of the Sixth Circuit's review, whether that Fifth Circuit stay should be lifted. If the Sixth Circuit decides to lift the Fifth Circuit's stay pending review, that's sort of our nightmare, right? We passed December 6th, the date that the OSHA ETS was supposed to go in place. In all likelihood, we'll have a ruling from the Sixth Circuit, and some people have said next week. I think that is wishing. Maybe the week of the 20th. Merry Christmas, happy holidays. Probably the week of the 20th or the week thereafter, maybe even into January is when we would have the Sixth Circuit's view on this. But either way, since we're past December 6th, creeping up on that January 4th second implementation date, we have this hypothetical where the rule is in place and employers have to comply with it unless OSHA gives us a holiday gift and says, you know what, we aren't going to enforce this while the Sixth Circuit's deciding what's going to happen. Or we're going to give everybody 60 days to get into compliance because we know that all of you put a stop while this was going on. But this is my sort of caution to everyone who has put the OSHA ETS out of their mind, is that it isn't impossible that the ETS quickly goes into effect. It's probably not likely, but it's not impossible. Certainly the Sixth Circuit could continue the Fifth Circuit's stay pending its own substantive review. I do think that's the more likely scenario. Our Sixth Circuit judges are very reasonable, practical folks. I think they understand the logistical nightmare that would go into place if they were to lift the stay. Is that the judicial reasoning that they would give us? No. But there is some practical reasoning not to lift the stay as they consider it. It's also possible that they could lift the Fifth Circuit stay and rule on the merits at the same time. I don't think that's likely. It's also possible that they could lift the stay and rule on the merits, thus making the ETS go into effect pending Supreme Court review. Even less likely to occur, but it's possible. So if the ETS does go into effect, this isn't really a very short-term issue. The OSHA ETS has made clear that it will likely be in effect for at least a 6-month period, that it of course reserves the right to extend that period if necessary. So while we wait, prepare as though the ETS will go into effect. I really don't want anyone caught flat-footed if we do get into the nightmare situation where the Sixth Circuit lifts the Fifth Circuit stay and now you have to be ready to implement immediately. I'm not suggesting that anybody roll out any policies, but have a policy, have a position, have a strategic way that you're logistically going to implement everything in your back pocket in case you need it. So first decision point would be, are you going to mandate the vaccine for employees or are you going to allow weekly testing? Now, most people have probably made this decision already. I will tell you, when I was thinking about how employers might approach this, I suspected that more people than not, more companies than not would mandate the vaccine. But as we started to have various discussions about employee retention, employee relations. The vast majority of my clients have ended up going with the testing option. So in case you're wondering, what is my neighbor doing? What is everybody else doing? I would say if I had to put some percentages on it, 90% of my clients are probably testing versus mandating. And of course, the testing option comes with a cost. Who's going to pay for the testing? If the employer is going to bear that, how many people are we bearing that for how long, operational challenges, and of course, all of this goes towards incentivizing or thinking about how we can incentivize vaccination so we can reduce weekly testing costs. And Beth is going to be here to talk about that kind of issue, because there are a lot of implications beyond just please get the vaccine. So questions I often receive about vaccination. Can we ask employees about vaccination status? Yes. Yes. I'm still surprised to get pushback. And often the pushback is not from HR or legal, but from our business folks who read headlines, not necessarily legal text, and who see in the news statements, including statements from politicians who say, well, of course you can't ask somebody about their vaccination status. That's HIPAA protected, or that's confidential information. You absolutely can ask employees about their vaccination status. In fact, under the ETS, you must ask employees about their vaccination status. Can we require employees to provide proof of vaccination? Yes, absolutely. Whether you're under the ETS or not, you can ask for proof. Can you have different rules for vaccinated individuals versus non-vaccinated individuals? And this is an interesting question. And it certainly raises fairness, employee relations issues. When it comes to specific health and safety measures, yes, you can differentiate between vaccinated and non-vaccinated. Under the CDC's guidance, vaccinated employees who are in close contact with someone who has had COVID-19, but who themselves are not symptomatic, do not need to quarantine. That's very different than the quarantine requirements for someone who's non-vaccinated and who has been in close contact with somebody who's positive. So we can have different quarantine requirements. We can have different masking requirements. I warn you about the backlash that is often received from employers who have very strict masking requirements for unvaccinated. Those employees tend to feel like they've got a red letter A on them, and you will hear from, in all likelihood, a minority of them who are not happy about the differentiation, but you certainly can. Now, be wary about how far vaccination status goes, and certainly keep an eye on state and local requirements. There are states, I mentioned Montana earlier, who have sort of put in place legal requirements that say you cannot treat vaccinated individuals different than unvaccinated. So all this should be caveated by what state are your folks working in. Who can know about vaccination status? The EEOC, the Department of Labor, has taken the view that vaccination status is protected medical information, much like other disability information would be protected under the ADA, which means vaccination status should be limited to a small group of need-to-know people. Generally, that means HR. Sometimes that can be supervisors if it's necessary. I think the best way to go about this is if you have a pretty strict rule that only unvaccinated employees must mask, that you provide supervisors with just the list of people they're responsible for. And the list is entitled, here are the folks who are vaccinated. The list is, here are masked required folks. Now, the people on that list doesn't have to be folks outside of their order, so we're not sort of giving information beyond what's need to know. And I would also say that you might have people in the workplace who are vaccinated but continue to mask. So the mask itself is not the determiner of whether or not there has been a COVID-19 vaccine. Yes, we tend to see more vaccinated people unmasked, but it's not a tit for tat. It's not a complete requirement. And then, are vaccination cards protected by HIPAA? No, so long as you receive them directly from the employee, HIPAA is not implicated. Now, that HIPAA word, and Beth can attest to this, gets thrown around. It's just colloquial anymore. It has a very specific meaning under the law, and it is not implicated when an employer asks an employee to directly themselves give them a vaccine card. So another sort of critical issue to think about as you're preparing in case the ETS goes into place is who's going to pay for the weekly testing? Let's say I've got 30, maybe 40% of my facility who are unvaccinated. I've gone through the process. I've asked people for cards. We've got a pretty high population of folks. I can't afford to lose them. I can't afford to replace them. We've got to do the testing option. But I also don't really want to fork over, $50 to $100 per test per employee per week. Can I pass that test on, the cost of that test on to the employees? And unfortunately right now the answer is there's not a lot of clarity out there. The DOL, under current guidance that was really more directed at testing for employees who might have been exposed to COVID, not the prophylactic, I'm going to make you test weekly, but the early guidance said employers who are going to require testing should pay for that testing. Again, that was directed at people who we thought might have COVID. The ETS says employers don't have to pay for testing unless required by some other federal or state law, which candidly isn't very helpful. To say to us, one side of the DOL is going to say you don't have to pay for it, but maybe another aspect of the DOL says you do, it doesn't give us a lot of clarity. If there's an accommodation for a medical or religious exemption, you need to be thinking about it not in the phrase of can I or can't I, but is it an undue burden on the company to pay for that testing? And unfortunately, to make things even more complicated, the definition of what is an undue burden under the ADA is very different than the undue hardship definition under the religious exemptions. So lots of things to consider as we're thinking through accommodations and testing. Concerns under the FLSA minimum wage overtime issues. Originally, the DOL had said in November that they were going to provide more guidance to us on this issue. We haven't seen it yet, likely in part because of the stay, waiting to see whether or not that guidance needs to be released. But at the end of the day, you should be worried about federal law, whether or not it's required, as well as state law, which does have implications. Some states have said you cannot require employees to reimburse you for medical testing required for work. Some states have gone so far as to say COVID-19 testing is medical testing under these state laws. Some states have reimbursement requirements like California and Illinois. Are those state laws broad enough to cover this type of testing? So the pay for testing issue is very dicey. It has to be analyzed under federal and state requirements. And I definitely would encourage you to reach out to your Thompson Hine lawyer to discuss that issue. Just in terms of documentation requirements, what should you be thinking about right now? An employee roster, having a policy that's either vaccination mandates or testing, and the notice requirements that are mandated under the ETS. I also wanted to talk a little bit about accommodations. So if you have mandated the vaccine, you must, of course, make accommodations for medical issues, those who cannot get the vaccine because it's contraindicated for them, because they have a disability, or for bona fide or sincerely held religious objections. These are the bane of employers' existence. And I can tell you that having had a few employers who mandated the vaccine before the ETS came out, and then some more employers who mandated the vaccine as the ETS was announced, you know, these are certainly things that employees are utilizing. And I would say some of them are utilizing them because they certainly have medical conditions that prevent them from getting the vaccine. Some of them are coming up with very creative medical issues, which they believe prevents them from getting the vaccine. And then we certainly have a tremendous number of religious exemption requests. When this all started, I predicted very incorrectly that we would have very few religious exemption requests, and the opposite is true. The vast majority of exemption requests have been religious related. And if you're like most of my clients, they haven't seen religious accommodation requests at all, ever. Maybe once in a blue moon. Maybe somebody has a certain religion and it prevents them from doing Saturday work. But beyond that, never have religious accommodation issues pass their desk. Medical accommodations certainly do, on a more frequent basis. Utilize your current medical ADA accommodation process to get doctor's information and analyze whether or not that employee has a medical condition that the doctor is certifying says means that they cannot get the vaccine. If they do, then you go through the regular ADA process of can you accommodate that individual. So a quick quiz question here. Darren is an employee with XYZ company. He has been telling anyone who will listen for the past year that he is not getting the vaccine. He believes this is a ploy by the Democratic Party to change his DNA and make him a liberal. XYZ has just mandated the vaccine, and Darren applies for a religious accommodation. He tells HR that it is his God-given right to make his own medical decisions, and his sincerely held beliefs do not permit him to be vaccinated. XYZ asks for a letter or documentation of this belief that Darren fails to provide because he does not belong to a formal church. So should XYZ company excuse him from vaccination? And the answer here, a little complicated with our web folks. I'm not going to ask you to click in or anything. The answer here is no. If Darren fails to demonstrate that the objection is based on a sincerely held belief. Couple of things to think about as we're going through the religious accommodation analysis. You know, Darren is a religion of one here. He is a one-person belief that, you know, I'm telling you, he's not the only person who believes this, but he doesn't belong to any formalized religion that is telling him not to get the vaccine. So I call him a religion of one. Under the EEOC's long-standing guidance, you can be the only person in your religion. Your religious beliefs can be unique. They can be illogical to others. That doesn't mean they aren't sincerely held, and it doesn't mean that they wouldn't qualify for religious accommodation. However, personal, social, political, or economic beliefs are not the subject of accommodation. Excuse me. So in this case, you know, I think you have to go through each and every individual religious accommodation and really analyze what is the employee saying about their belief system. Do their beliefs that they should not get the COVID-19 vaccine hold the same sort of water and truth as other religious beliefs? You should certainly, unless you have an objective basis for saying otherwise, consider everyone's beliefs to the default as being sincerely held. And I can say, having looked at more than 50 religious accommodation requests, they're all sincerely held. I mean, the people who make these accommodation requests are doing them because they do not want to get the vaccine. The question is not really sincerely held. The question is it a religious belief? So you don't have to accept every single religious accommodation request as being religious if in the context of what the employee is providing, there doesn't happen to be religion. And the best way to kind of analyze this, I think, is, let's say you did grant an employee's belief that God told them, or a divine being told them not to get the vaccine. What happens if 2 months from now, and let's say that's the only basis for their objection, if 2 or 3 months from now that employee comes to you and says, God has told me not to work overtime. My belief has now changed, not changed, I still don't want the COVID vaccine, but now I need to be home with my family. And that's now my religious belief. So analyze it in terms of what they said, but also in terms of how broad is that religious belief system? Is it anchored to anything? Is it anchored to religious texts, to other belief system, or is it simply the employee sort of stating, I don't want to do this, and I'm going to cloak my desire not to do this in just a very generic, general belief in God? Now, I wholly suggest that everybody go through counsel when they're working through these specific accommodation requests. They are dicey. They depend on which circuit you're in. Certainly some federal courts of appeals have much better precedent in what I call the flu shot cases, hospitals that have had to analyze employee religious objections to getting the flu shot. So there are different precedents in different jurisdictions, making it more or less risky to deny a religious accommodation request. My sole point is simply, you do not have to accept every single religious accommodation request if you believe that there is no religion behind the requested accommodation. Okay. XYZ determines that it is not going to challenge Darren's sincerely held religious belief. It then begins to consider accommodations. Darren cannot work at home. He must be in the workplace. He has told his supervisor that he is willing to test weekly, but because this is a religious accommodation, XYZ must pay for it. XYZ has approved religious accommodations for about 25% of its employees and is facing significant weekly costs to test those employees and track results. Therefore, it rejects Darren's requests and places him on indefinite unpaid leave. And we've certainly seen, not our clients, but large airlines have been in the news taking these unpaid leave accommodations. Can XYZ take that action? In my view, yes. If there is the view, if XYZ determines that the cost of the testing imposed is an undue hardship. Okay, so answer A. If it's not just Darren, if it's other folks as well, you can take into account those individuals. And as I mentioned before, the standard for undue hardship under the ADA and the standard for undue hardship under religious accommodation requests is very different. And under religious accommodation requests, our threshold for having an undue hardship is very low. And minimal costs, much less significant costs, can constitute an undue hardship. So some last practical tips before I turn it over to Beth. Do not wait for the pending litigation to resolve before you start making your plans. If the stay of the Fifth Circuit occurred and you shoved everything regarding the ETS into a file somewhere and you have not looked at it since, pull it back out, dust it off, understand what you would need to do if implementation was required in short order. Certainly by now, I've encouraged our clients to understand who is vaccinated and who is not, putting that OSHA ETS roster together from the get-go. Determine whether you're going to require the vaccination or allow testing. Proactively communicate with your employees who are very worried about this issue Either calm fears, let them know that you're on it, but just kind of keeping them in the dark has not been very successful. Draft policies and processes so that you will be ready to implement if needed. And lastly, designate a compliance point person. Have someone in HR, EH&S, legal, who is keeping abreast of all of these changes so that we know when and if we need to implement. Make a plan for testing. OSHA doesn't expect supply chain issues. I feel like I see supply chain issues every night on the news. I think there would be testing supply issues. Maybe I'm wrong. Create an accommodation process, one that's formalized so that you can address all those issues that we discussed earlier. Train your supervisors and managers about what they can and can't say, what they do or don't need to be doing. And finally, OSHA does have, if the ETS goes into effect, the right to come and determine whether or not you're in compliance. I don't think by any measure that OSHA is going to have the time or the resources or manpower to come knocking on everyone's door. In all likelihood, OSHA is going to investigate those companies for whom they received complaints from employees that you are not complying with the ETS if it goes into effect. So do your employees, if OSHA starts knocking, know what to do? Are they prepared? And with that, I will turn it over to Beth to talk about COVID-19 testing and vaccination considerations from a benefits perspective.
Thanks, Beth. Thanks, Megan. So continuing the theme of nightmares, I feel like I am the Babadook who comes up from the basement every time I get a call from one of my clients who says, okay, my team has come up with a great plan for how we're going to handle this ETS and how we're going to handle the weekly testing. And here's what it is. And then I have to say, ooh, well, there are a couple benefits related issues that we should probably consider before you put that into play. And let's think about how we might need to, redesign this a little bit. So I am going to be talking this morning about two basic concepts that people often get confused. And I want to make sure that I'm defining the scope appropriately so we can sort of think about these as separate buckets of issues. So the first bucket really deals with what are the benefit implications that come into play when you are just simply paying for or providing vaccines or testing to your employees. Not talking about incentives here, we're just simply talking about making these, potential benefits available to employees. And then the second bucket of issues that I'll talk about relates to the incentives and what comes into play when you start adding incentives to these programs. So starting first with the basic testing and vaccination. If an employer is providing or otherwise paying for vaccination or testing for employees, there are a number of benefits issues that could come into play. Now, what do I mean when I say otherwise paying for? Basically, we're talking about, you are hiring a third company to come in and administer testing for employees. That third company is not charging anything for employees, you're just paying for the whole program. If you are reimbursing employees who go out and get tested on their own and then come in and say, okay, I got tested at CVS, here's the charge, you're going to reimburse me for this. So there are various ways in which an employer can ultimately end up paying for vaccines or testing. And the key issues that we want to think about when providing these services to employees is, are we actually creating a group health plan by doing this? And if so, we're likely to be subject to ERISA, COBRA, and HIPAA. So if we do create a group health plan, how are we going to make sure that we tie off all of those compliance concerns? Get our plan documentation in place, get our employee disclosures correct, deal with COBRA and HIPAA privacy considerations, and various other requirements. And then the response that I get a lot of times from employers is, well, we are already paying for testing and vaccines. We're required to, right? We have to pay for it under our group health plan. And that is absolutely true. At the moment, under the Families First Act and the CARES Act, most group health plans have to provide coverage at 100% for certain approved COVID testing and for vaccines. But the COVID testing that's required to be covered under group health plans is testing for diagnostic purposes. And we have guidance that explicitly says that does not apply to testing for general workplace health and safety. So general fit for work testing falls outside of that scope. And another thing to think about when I hear employers say, well, we're already providing it through our group health plan, can't we just do it that way? Maybe you can amend your group health plan to provide for broader protection or broader coverage than what is required under Families First and CARES Act. So if you have a self-insured plan as opposed to a fully insured plan, you're going to have more control over how you design that self-insured plan. And you can possibly amend your plan to allow the plan to cover COVID testing for general workplace health and safety. The issue, though, that oftentimes makes this not the perfect solution is that in most cases, employers set limits around who can participate in their group health plan, right? So you may limit it to full-time employees, you may exclude interns, there may be certain segments of your population that do not participate in your group health plan because they participate in a multi-employer union plan. And so offering it through your group health plan might be part of a solution, but likely isn't going to be enough to reach the full employee population if that's the goal. So if you're trying to, for example, come up with a way to comply with this ETS in the event that it goes into effect, offering it under the group health plan probably isn't a one and done solution. So then we have to look at, okay, what are the potential other opportunities or ways that we can provide this, these services to employees? You could basically just set up a weekly testing program outside of the group health plan, offer it as, you know, part of an on-site clinic, offer it in the form of an EAP, Employee Assistance Program, to do pop-up events. But then the question that arises with respect to all of these solutions is, if you are paying for the vaccine out of an existing group health plan, outside of an existing group health plan, are you creating a new ERISA group health plan? And if so, you need to make sure that you're addressing compliance for that new group health plan. So key question when looking at testing for purposes of workplace safety or testing for purposes of compliance with the ETS, is that type of testing actually medical care? So group health plans are ERISA welfare benefit plans that provide medical care. And ERISA defines medical care as the amounts that are paid for the diagnosis, cure, mitigation, treatment, or prevention of disease, or for the purpose of affecting any structure or function of the body. It's pretty broad. But we do have some precedent from the DOL in looking at workplace drug screenings that there might be some types of testing or screening that, even though they may affect a structure or function of the body, they would not necessarily qualify as medical care for ERISA purposes. And the DOL, in looking at drug screening that was required as a condition for employment under a CBA, basically said that the union is paying for this drug testing solely for purposes of meeting a condition of eligibility for employment. They're not providing any counseling or care in connection with the drug testing. They're not really using it in any diagnostic or medical purpose. It's solely a screening purpose. So you might think, okay, great. That's totally what this testing under the ETS standard is. This is purely, you know, safe workplace. We are not looking at treating these individuals. end of story. Unfortunately, it's not the end of story because we, of course, have conflicting precedent from courts, including a case out of the Ninth Circuit, which looked at medical tests for airline pilots, basically to determine if the pilot was fit to fly, and distinguished this drug testing guidance, basically saying, look, when they're looking to see if somebody has drugs in their system, they're not looking to diagnose any sort of medical condition. They're simply looking at that particular snapshot of time, no drugs in system. They're not doing a broader analysis to determine whether the person potentially has a substance use disorder. They're just basing it solely on, okay, you have, pot in your system on this day, so you are not hired. And the court out of California said when you engage in tests that are seeking to basically diagnose medical conditions, that those would be considered medical care and would need to comply with ERISA group health plan requirements and all of the compliance that goes along with that. So we're really in a gray area here. And so it's kind of up to the client's risk tolerance as far as whether they want to take a conservative approach or maybe take a more aggressive approach. But most of the clients who I've spoken to, once we work through what it's going to take to put some compliance around a testing program, they oftentimes decide that it's worth it to just take that conservative approach. So let's talk now about what that might look like. So if you are viewing paying for weekly testing as a group health plan, then you need to basically think about ERISA and having some sort of written plan document, summary plan description, taking care of the Form 5500 filing, COBRA, which we'll talk about in a moment. Sounds daunting, but there are ways to address it. HIPAA, privacy, again, that always, when I raise that word, people are like, oh, no, get me out of the room. I don't want to deal with this. But it's not as daunting as it sounds. And then ACA preventive care mandates. So options for addressing ERISA. It's actually pretty easy to sort of shoehorn a benefit like this into an existing benefit, or just create a new plan and do some minimal documentation around it for compliance. So if you maintain it as a separate plan, separate from anything that you're already offering, we would create a new plan document. You would have to file a separate Form 5500. You would create a new SPD. Again, doesn't necessarily have to be the 100-page SPD that you might think of when you're thinking of medical plan SPDs. Could be much smaller, scaled down than that. The other option, which I think is more attractive, is that you integrate it with a current benefit program. So, for example, most employers already have an EAP, and you could basically integrate this with your current EAP and say this is the COVID portion of your EAP. And if you're already providing vaccines, you could wrap in the vaccines and the testing into this new portion of your EAP and then build some documentation around that. You're likely already filing a 5500 for your EAP, so you would just basically include this information when considering that 5500 filing, and you're done for ERISA purposes. For addressing COBRA, a little complicated. So technically, COBRA would have to be offered for a program like this if it is medical care. Now, I know what you're thinking. Why would anybody want COBRA for this? If they terminate employment and lose coverage under this, they're not going to have any need for weekly testing, which in most cases is probably true. There may be some employees who get terminated and maybe, to stick it to the employer, they decide they want to come back and do weekly testing every week. Maybe they're going to try to satisfy the testing requirement at their new employer using your services. There are a couple different options for dealing with COBRA. One of them, the basic COBRA option, you just offer COBRA to employees. You send them out the COBRA election notice. You charge a premium. You make them elect it if they want the coverage and pay the premiums. But we know that a lot of times the cost of sending out those COBRA notices can be more expensive than what the actual premium for a program like this might be. So a lot of times when dealing with programs like this, employers just actually automatically continue coverage. They drop a little paragraph in the SPD. They say if you're terminated, if your coverage is terminated and you would have qualified for coverage, you're going to get extended coverage under this program for 18 months. And employees hardly ever read that. So employees hardly ever take advantage of it. So that's another option to go. We've talked also about, creative solutions for addressing the COBRA issue. Basically, if you draft your program such that an employee is only eligible for this weekly testing, if it's required for purposes of, coming into the office or for purposes of performing services for the employer, then technically, once an individual is terminated, they're no longer meeting those basic eligibility requirements, and you could potentially deny coverage based on that. However, just, theories that we're throwing around untested, but people looking to take a somewhat more aggressive approach, there are potential ways of addressing this in a creative manner. Options for addressing HIPAA and ACA. So again, two kind of different issues, but the solutions oftentimes intertwine. So the issue under the ACA is that separate and apart from the employer shared responsibility ACA penalty tax that employers are most often familiar with of dealing with, there are issues of ACA compliance that relate to certain benefits that have to be covered under your plan if you are offering a group health plan. Those include certain preventive benefits, preventive services that have to be covered at 100%. If you are offering a group health plan that only covers vaccines and testing for COVID, you're not going to meet those ACA preventive services coverage requirements. So the way around it is that you design your program so that it's considered to be an accepted benefit for ACA purposes. And that gets you out of the requirement to cover all of the preventive services and gets you out of some of the other limitations that would apply if you were not an accepted benefit. Additionally, another benefit of designing it as an accepted benefit is that in some cases that can get you out of HIPAA privacy and security compliance as well. So we see on-site clinic here as an example. On-site clinics, for whatever reason, decided years ago they are not subject to HIPAA privacy and security requirements that apply to group health plans. Now, there may still be medical providers providing services in that clinic who themselves are subject to HIPAA privacy and security, but for the employer's purpose as a sponsor of the group health plan on-site clinic, not going to be subject to HIPAA privacy and security under the plan. Also not going to be subject to the ACA coverage mandates. So that basically takes care of HIPAA and ACA there all at once. If you're not offering it on-site, though, through something that we could consider an on-site clinic, you could do it as an EAP, an employee assistance program. This would get you out of the ACA preventive service coverage requirement because it would be considered an accepted benefit as long as the employee assistance program meets the other requirements for being an accepted benefit, including that you couldn't charge any premiums to employees, you couldn't implement any cost share, all things that we would encourage you to call us about, because everything that I'm talking about here kind of has like 3 layers underneath it that we would want to talk through. But if you design it as an EAP, it'll be ACA compliant. It will still have to comply with HIPAA privacy and security. So then how do we deal with that? Let's see, I've got 6 minutes left. The best way to deal with HIPAA is basically not have the health plan act as the middleman. So you don't want to have the health plan giving anything to the employer. And I say this understanding that there are going to be employer personnel likely, working on the health plan side. You sort of have to silo them and make sure that if employers in HR, for example, are administering or proctoring back the testing, that those individuals are not then giving the results to the employer. The safer route is to basically have employees go through testing, give the employee the results and have the employee provide the result to the employer or upload the result to some sort of data system where you're maintaining those results. That will essentially bring it outside the scope of HIPAA. And I want to get to just a little bit about incentives really quick in the last couple minutes. So moving on then to the second bucket of issues that I was talking about. Once we get into the option of providing incentives in connection with getting vaccinated, then there are a whole host of other issues that have to be considered, including HIPAA wellness program requirements, potentially ADA wellness program requirements, and then additionally Title VII and various other issues. So looking at just a couple examples. So example one, you're an employer offering a gift card to employees if they simply show you proof that they've been vaccinated. This is probably the easiest and cleanest way to go about designing an incentive program. In this case, neither the ADA or the HIPAA wellness program rules would limit the amount of the incentive or otherwise impact the design of the program. COVID-19 vaccines are not considered medical examinations under the ADA. That's important, under the ADA. They would still be considered medical care under ERISA, HIPAA, and so those requirements may still come into play. Proof of vaccine requirements alone are not likely to elicit information about a disability. So an individual basically showing you their vaccine card is not likely to include information about a disability that would trigger ADA protections. In contrast, if you as the employer or an agent of the employer is actually administering vaccines on site and asking questions of employees to make sure that they're actually fit for receiving the vaccine, that could elicit information about disabilities, and that could trigger ADA protections under the ADA wellness rules. And in this case, the incentive is not provided in connection with a group health plan. So we're not dealing with any sort of group health plan surcharge or premium reduction as the incentive. We're dealing solely with a gift card or some kind of cash incentive. Cleanest way to go about it. All right, example two. Cash is available. So again, not dealing with group health plan issues. You're just providing cash if the vaccine is administered by a provider under contract with the employer. In this case, we start to get into those ADA wellness rules that could apply because you have somebody, an agent of the employer, proctoring the exam. There's the potential that you're going to be asking information that could elicit disability information, and therefore the ADA wellness rules will apply. Let's see, now it's frozen up. This is always fun. Okay, I'm just gonna go on from my notes. I don't know what's going on. It's not working.
Go ahead.
Okay, I'm gonna keep going. Megan's gonna try to intervene with the tech here. All right, so let me get to the, oh, there we go, thanks. Okay. So in this case, these types of incentive programs have to satisfy certain ADA wellness program rules. The key there is that there are certain notices that have to go to employees before they participate in the program, and there are requirements that the incentive has to be structured such that it's voluntary, or such that it's not so coercive to make the program be deemed involuntary. We currently don't have any safe harbor or any real guidance on what level of incentive that might be, though we have some past guidance that might be informative. Definitely something to follow up with counsel about if you're considering this. And then we have the third, which is the most meaty example. I'll go through this quickly. This is basically the premium surcharge or premium discount example. when you are thinking about offering a premium surcharge or discount to your group health plan in connection with vaccines, there are a ton of issues to consider. This would be considered a HIPAA health contingent activity only wellness program. We did get clarity on that earlier this year. There are limits on the incentive that can be provided. So in general, the incentive cannot exceed 30% of the cost of coverage. That's taking into consideration both the cost paid by the employee and by the employer. So an easiest way to think about it is the COBRA premium. What would your COBRA premium be? And then that limit bumps up to 50% if you also provide a tobacco surcharge or premium reduction. There has to be a reasonable alternative method of meeting the incentive requirement or a waiver that's provided to individuals for whom it's unreasonably difficult due to a medical condition or for whom it's medically inadvisable to obtain the vaccine. Just gonna get to, the program has to be reasonably designed to promote health and prevent disease. In this case, with most COVID vaccine incentive programs, you're likely to meet that. So that's not a huge consideration. The program must give individuals eligible for the program an opportunity to qualify for the reward at least once per year. This is key because you have to consider then when you are setting, for example, deadlines for the satisfaction of the vaccination requirement or the reasonable alternative standard. If you set a deadline of mid-year, July, and somebody meets those standards mid-year, you have to give them the full year reward. So you're going to have to reimburse them for any amounts that they paid over what they would have paid had they been vaccinated or met that reasonable alternative standard. And because of this, a lot of employers like to basically announce these incentives in the fall around open enrollment and give a more limited window for individuals to meet the requirements. So maybe, by January 1st or by the end of February. And then another thing that has to be considered are new hire applications. So what are you going to do with new employees? Do you just waive the requirements for the first, partial year of their employment and give them the reduced rate, or do you give them a month or two to meet the requirements? All right, and I am over time, so I will stop there. But if anybody has, oh, okay, Stacy's telling me I can go on. So I've only got a couple more slides. I'll just, so this is a key thing actually. In determining the amount that you're going to charge for a premium surcharge or a premium reduction, you will need to think about ACA affordability. And this gets back to that employer pay-to-play ACA penalty issue that I brought up earlier. So in determining the rate that's used to identify whether your program is affordable for employees, you have to take into consideration any surcharge that's being provided to employees. You may not take into consideration any premium discount. So it's a little bit different from the tobacco incentives because we have specific guidance for tobacco incentives that says essentially those can be ignored when you're looking at ACA affordability. Incentives for everything else have to be taken into consideration. So COVID vaccine incentives have to be taken into consideration. So if you are implementing a $100 surcharge, $100 per month, and your base premium is $100, the premium that you're going to use in determining whether the coverage is affordable for employees, and that includes all employees who both qualified for a waiver of the surcharge and employees who are actually paying the surcharge, it would be $200 taking into consideration that surcharge. And so plans are, generally looking at their affordability months before the plan year begins so that they can try to mitigate ACA penalties. This is definitely something that you want to consider if you're going to throw a surcharge or a premium reduction into the mix. And then, okay, so key takeaways. Determine whether the health plan will cover COVID-19 testing that's conducted for employment purposes. If you're going to pay for testing or the vaccine outside of the health plan, determine what sort of compliance requirements you might have to address. If you're going to provide incentives, again, ensure that the design is in compliance with incentive program requirements. And I did not get into, there are a whole host of other considerations that should be looked at when designing these incentives, including CBA issues, Title VII, general ADA protections that might require accommodations. So tons of issues, definitely feel free to call us. Thank you very much.
Okay, thanks, Beth. Without a doubt, I could sit through that presentation multiple times and still learn something new each time you talk about it. So as we end here the first segment, and I will repeat these at the end of the day, the first CLE tracking code is TH128C. Beth and my contact information is available there. Thank you to Stacy Jenkins, who is our next presenter. Is going to provide immigration updates for everyone. And again, appreciate everybody's time and attention today. So I will turn it over to Stacy.
When people are much taller than me, that's very obvious. Okay. Hi, everyone. Thank you so much for being here with us remotely. And for those in person, thank you for taking the time as well. I'm going to give you a little bit of updates on the immigration challenges that we have faced during COVID, as well as some of the current trends that we are also facing as we're coming out of all of this. So, some of the primary things that we're going to talk about will be first, limited consular processing. We're seeing a lot of issues with that are still continuing, and we anticipate, unfortunately, to continue for quite a long time. So we'll give some updates on that, talk through the travel bans, which a lot of us hoped were going away, and we're just surprised about 2 weeks ago with some new ones that have been put back into play. And we'll talk about some additional entry requirements on the travel issues as well. As a whole, international travel is still continuing to be significantly impacted by COVID. I'm going to talk through a lot of the vaccination issues and some things along those lines too. So first, in terms of limited consulate processing, most of the U.S. consulates are only offering emergency visa appointments right now. We have started within, I'd say, the last 1 to 2 weeks to see a little bit more opening up for regular appointments. For example, I have several individuals who are in Costa Rica that just were advised. They had appointments that were scheduled out, I think, in March or April, and they just got rescheduled for December or January. So we are starting to see some opening, but as a whole, many of them are only accepting emergency appointments, and a lot of them you can only request them once the individuals are in the country as well. So it's creating a lot of uncertainty for individuals who don't want to leave the U.S., not knowing if they can get back in or not. So we have a lot of, I'd say, anxiety, uncertainty, among foreign nationals, because let's be honest, it's been about 2 years. They haven't been able to travel. They haven't seen their families. I can only imagine how difficult that is. And while a lot of us are starting to feel like in some ways things are returning back to normal a little bit, for them it's really not. And we're seeing that most at the consulates. We also are still seeing that routine schedule appointments may be canceled. So individuals might have that appointment scheduled, and if the consulate isn't ready to reopen, or they're at a reduced capacity, or maybe COVID levels are high in that area again, so they've got limitations, someone might have an appointment and then suddenly the week before be notified that that appointment is canceled. So there's just a lot of risk with that travel. Another thing that we're still seeing is that a lot of U.S. consulates are not allowing third country nationals to apply for visas. So what that means is third country nationals are the individuals where, let's say, someone's in the U.S. who's from India, historically, before COVID, they may have been able to go to Canada to apply for their visa so that they didn't have to go all the way home to India. Or maybe they had a business trip to Europe and they wanted to maybe apply in London. Historically, they could do that. Right now, we are really seeing that the consulates are not allowing that. What the consulates are saying is, look, we're backed up enough. We didn't do appointments for a year. We're still only accepting emergency appointments. We're only going to give appointments to people who are either from our country or who are legally present in our country at the moment. So that's really what we're seeing on this. So third country nationals are those who don't fall into one of those categories. And we're just seeing across the board, a lot of them are not accepting appointments for those individuals. So I do want to say, we started particularly in October, the end of October, seeing what I would say were signs of hope in terms of international travel for these foreign nationals and for people coming into the U.S., okay? So, on October 25th, President Biden issued a proclamation that was going to do away with these geographic COVID travel restrictions. So the ones that used to be in play prior to this were very significant. So essentially the Schengen area, so a large portion of Europe, India was in it, Brazil was included, China was included. There was a very long list of countries that were included. And what that travel ban said was that if you had been in one of those countries within the 14 days before your entry to the U.S., you couldn't enter the U.S. unless you fell into one of the exceptions. And this was, using air travel. So, which if you're coming from Europe, if you're coming from one of those places, you're going to have to be doing. So it really was prohibiting individuals from entering the U.S. unless they could qualify for one of the exceptions. President Biden said, okay, look, we're going to do away with that. We're going to go to a more individualized approach that's focusing on should we let the individual in? Are they vaccinated? Have they tested negative? Things like that. And I'll go into that in a bit more detail. But everyone, I think, was extremely rejoicing. It's like, okay, as of, I think the actual date was November 8th. This is all going to open up and people can enter. And we had a period of time where that occurred. But let's not, get too far ahead of ourselves, because just recently with the, existence of the new variant, what we are seeing is now those are gone, but now we have another one that has gone in its place. And it is focusing on countries in, South Africa region. So, there's, I think, 7 countries, I've got them listed here, that again, it's almost that identical travel ban that existed before that we're seeing again just for these countries instead. So as I mentioned, it prohibits entry to the U.S. if you were physically present in one of those countries within the last 14 days. It does not apply to citizens, to lawful permanent residents, to non-citizen nationals. It also, there's a list of immediate relatives of U.S. citizens or permanent residents. So for example, if you are the parent of a U.S. citizen child, then it's not going to apply to you. You have one of those exceptions. At the border, at the border you would show, okay, here's the evidence of my child, here's the evidence that the child is a U.S. citizen, please, let me in. So those things are still in play. There are also a few other exceptions, and one of those is a national interest exception. What we don't know, though, is how they're defining national interest. They have been silent on that so far when it comes to this proclamation. What we can say is that they previously defined national interest, in terms of certain things. There were some humanitarian needs, or there were, certain things that you could show it was very important that you would be in the U.S. and you would apply for that national interest exception. As I said, though, that was for the other proclamations, and this has not specifically defined that. I will also say, as of, I think, the end of last week, if you emailed the consulate the email that you're supposed to send, a request to get a national interest waiver from Johannesburg, if you email that email address, it currently says the email address does not work. So we just don't, we're still, very much in the dark about what this is going to be and if they're going to issue these national interest exceptions. The one other thing that is unfortunate is when President Biden did away with all of the prior travel ban or physical presence bans, however you like to call them, he said that anyone who had an NIE already issued, all of those were null and void. So all those people who went through the process to show that they had a national interest reason to be in the US, the government said, yes, we agree. It doesn't matter that it's already been issued. They would have to have it issued again. So we really are at a starting point with this particular travel ban in terms of how are we going to handle that and what are we going to see moving forward. And there's just a lot of uncertainty. The one thing they did tell us is that it's going to act in combination with other proclamations such as the vaccination requirements and the COVID testing requirements. So again, we'll get to those in a minute, but even if someone says, yes, I get a national interest exception, they're still going to have to comply with these other items such as the vaccination requirements and things along those lines. As I mentioned, before that went into place, we really thought we had done away with these geographic bans and we were going to be going to a completely individualized approach. And that's really how, the administration put it forward to us and CDC and all others put it forward to us is, okay, we realize these geographic approaches aren't really helping, maybe, or at least not to the extent that we thought, and we should really take an individualized approach. And this is, the next few things we're going to talk about are what that individualized approach is. And it continues to be in place for everywhere except those countries near South Africa and South Africa. So the individualized approach is two-pronged. One is requiring vaccination and one is requiring COVID testing. And I'm going to go into detail because I will say right now, this is pretty confusing. The part I'm going to talk about first is the vaccination piece of it, and this is really related to non-U.S. person travelers. That's the language that they utilize. And really what they're talking about here are, if you're a permanent resident to the U.S., this doesn't apply. The vaccine portion doesn't apply. If you are a U.S. citizen, that portion doesn't apply yet. So keep that in mind. We are talking about non-U.S. person travelers for these vaccination requirements. I will also say that as of right now, one of the things that is very confusing about this is it depends on your method of traveling. If you are traveling via air, there's one set of requirements. If you're crossing the border via land, there's another set of requirements, and we'll talk through both of those. So let's focus first on air travel. So essentially what this proclamation does is it suspends entry for non-U.S. persons who are not vaccinated. And if there's an exception for someone, they do have to follow very specific guidelines set by the CDC related to health and safety requirements. But I'm going to tell you there are very few exceptions. So going into a bit more detail. For non-U.S. passengers, they're going to have to provide proof to the airline of their vaccination. Now, one thing that a lot of people have been struggling with this is, yes, the government's not necessarily making the determination if someone meets the vaccination requirement. The airlines are. The government has put this burden on the airlines to say whether or not someone meets the standard and is allowed to enter. So it's not TSA. It's not a government official. Sometimes when you would travel, I don't know if you did, I went somewhere during COVID and I had to have proof of negative testing, or you have to have proof of a vaccine, and there were actually, government officials when you landed asking you about this. That's not what's happening. It's the airlines who are putting this into place. And I think there's a lot of concern and just uncertainty and concern even about airline delays and things like that. So if you're entering the U.S., the one thing I will say, tip from this, get there early, because even if you don't have to have the vaccination, people on your flight might, and this could delay being able to get that, get through and get onto that flight. But that being said, what the airline is looking for, they have to match the name and the date of birth on the vaccination document to your travel document, so most likely to your passport. They have to determine that the record was in fact issued by an official source within the country that it was given. And then they are also required to review the information about the vaccine to make certain that it meets the CDC requirements, because I will say we don't accept all vaccinations. So it's only the ones that the government has said, yes, this is an acceptable format that we're willing to, or an acceptable vaccine that we are willing to. And the way that they've defined that, and we'll go through the specific ones, I'll show them to you in a moment, but obviously the FDA ones are included. But then also there are the ones from the World Health Organization that are also on the list of approved vaccinations, because there are a lot of vaccines that might be available in the US that aren't available abroad. So they had to make it broader than just the ones available here. In terms of what they're looking at, the CDC has said that they can look at 3 types of documents in terms of, proving that they've had the vaccine. One is a verifiable digital or paper record. So they can actually look at this record and tell that whether it's because of, a certificate or a digital authentication, yes, this is in fact an official vaccine record. I'm going to tell you, probably a lot of countries don't have that. So the government realizes that, and they've made additional exceptions. Or additional items that they will accept. One is a non-verifiable paper record. So a paper vaccination record that they believe is accurate in the nation where the individual is coming from. So I will tell you, I would likely put our vaccination cards under this. Now, again, we don't have to show ours because you're a U.S. citizen, or those of us who are here who are U.S. citizens, permanent residents, don't have to meet this standard yet, but that's the type of item that we would be looking at. Then the other thing is a non-verifiable digital record. So a photo of the vaccination card or the record, which I know this is definitely one of the things that I always carry with me. I don't carry my card. I have a picture on my phone of the card, and that's what the type of document that they would be looking at here. These are just, and I'm not going to list each one of them, but these are the different, the different vaccines that are determined acceptable under the regulations. Now, what I will indicate is they have made an exception. So in the US, they've indicated typically you're supposed to have, 2 of the same. So if it's a Pfizer 2-part test, you have 2 Pfizer. What they have indicated, because some countries don't have that availability, they will accept a combination of some of the 2-part tests. And you have to be within 2 weeks of the receipt of the last dose of the vaccine. So if it were a J&J vaccine, 2 weeks from dose 1, because there is only 1 dose. If you're looking at Pfizer, Moderna, or some of the other 2-dose vaccines or combinations of 2-dose vaccines, be 2 weeks after the final vaccine. I do want to just mention along these lines, that it's the 2 full weeks, which they actually look at as 15 days, because you have to be at least 2 weeks beyond. So that's important to keep that in mind as well. So that's air travel. Vaccination requirements for air travel, remember, those are for non-US persons. Now I'm going to go into land travel, because the requirement is different. So if it's land travel, it varies if you're traveling for an essential purpose or if you're traveling for non-essential purposes. So recently, the government did open up the borders, probably about a month ago, where they said if you're coming from Canada or Mexico, we're now allowing non-essential travel. So essentially tourism again. You're allowed to cross the borders for those purposes, because until just recently, you were not. If your only purpose was to go across the border to, visit Vancouver, you were not able to do that. There had to be, whether it was a business purpose, whether you were going for, actual work authorization purposes, that needed to be in existence. So that's just to kind of define essential versus non-essential. And we'll go into a list of essential as well, but just overall broad scope of that. So if you are a non-US person, you need to be ready to provide proof of your vaccination status if it's required. And then you also need to be able to verbally attest to the reason why you're coming. Because again, if you're coming for essential, the reason your requirements are going to be different than non-essential. So unvaccinated travelers right now, if you are coming for essential travel, are allowed to enter at this moment. They are anticipating that that will go away as of January. So we're getting close, but as of right now, if a truck driver is coming across the border, that's something where they don't have to be vaccinated necessarily. They're coming for essential purposes and they can enter without vaccination. But again, as of January 22nd or January of 2022, we anticipate that that is going to change. I do have listed here, examples of essential travel. So first of all, U.S. citizens, lawful permanent residents coming to the U.S., that's essential. That's why we're defining this as applying to non-U.S. persons. Individuals who are traveling for medical purposes, it's likely going to be essential. Traveling to attend an educational institution is viewed as essential. Traveling for work in the U.S., whether it's that truck driver crossing the border, whether it's someone who has TN work authorization to come to the U.S., those things are currently going to be viewed as essential. Here's some more. If they're traveling for emergency response or public health purposes, if I mentioned the lawful cross-border trade, that might be where the truck driver could fit in as well. If they're engaged in official government travel, if they're a member of the armed services, or if they're in military-related traveler operations. These are the types of things that are going to be viewed as essential. They don't yet need the vaccine. Again, they will. So keep that in mind. It is coming, but as of right now, land crossing, it is not required. So now I'm going to move on. So we've talked about the land crossing versus versus air crossing. I want to move on now to, and that was all vaccination related. Now we're going to talk about the COVID testing requirements. You remember I said there's two prongs to this. One are the vaccination requirements. The next is the COVID testing requirements. The COVID testing requirements apply to everyone. So we're not talking about non-US persons anymore. We're talking about US citizens, permanent residents, absolutely everyone when we're talking about the COVID testing requirement. I will say the government made my presentation a little bit easier about a week and a half ago, because there used to be this complicated system of certain people you had to test 3 days in advance, other people you had to test 1 day in advance. If you were vaccinated, it was one way. If you had a child, it depended on who they were traveling with. It was extremely confusing in my opinion. That's not the case anymore. They've simplified it, but they've also made it a little bit harder. There's people who used to have 3 days, no longer have that. So now you have to have a negative COVID test within 1 day of entering the U.S. Now, I do want to say there have been some news outlets that have been reporting it as 24 hours of entering the U.S. It is actually 1 day if you review the CDC guidelines. And that is important because let's say you're flying in or you're crossing the border on Friday and you get your test on Thursday. Let's say you get your test at 8 a.m. Your flight was supposed to be at 7 a.m. You were in the clear on Friday because you got it, within the 24-hour period. Well, your flight gets delayed 3 hours. What does that do? So, the government did want to provide a little bit more flexibility. So it's within the day prior. So any testing that occurs on Thursday will allow you for entry on Friday. So just that was one thing that they gave us to us. So, and it's all individuals who are 2 years or older have to have that negative test within the 1 day of entry. There are some limited exceptions, but they are very tough to qualify for. So there are some medical exceptions, but it's very detailed as to exactly what you need in order to qualify. You can't just claim that at the border without having the right documentation. There are exceptions, for example, if someone is part of a COVID vaccine trial, they might be accepted in certain circumstances. So those exceptions exist, but they are much more limited, and you have to have proof of that. One other one is if you can show that you have had COVID, I think, within a certain period of time, because then obviously you may or may not test negative, but if you've had it within a certain duration, I believe it's 90 days, but don't hold me to that, then you are also exempt from the showing of the negative test. So the other thing I just want to mention is, as I said, even though we're lifting the travel bans, even though, as a whole for most countries, we've listed the geographic bans, I mentioned that the consulates are very behind in having emergency appointments only. I want to raise that again. The DOS has said to several different groups, okay? AILA is one that I'm very involved with. It's the American Immigration Lawyers Association. But they've mentioned this in several different of their, facts that they'll have with different groups. They anticipate that they are not going to go back to normal processing of visas until 2023. That is how long it is going to take for the consulates to get back to the point that they were at pre-COVID. So when you're thinking about your employees and you're thinking about travel, it's just very important to keep that in mind, because they are going to, be facing this issue for quite some time. So the next thing I do want to talk about, and this kind of goes to that consulate availability and how it plays into that, is how COVID has impacted green card processing. So, what happened is there are green cards, and when they're issued, there's two different ways you can get a green card. You can either get one by being outside of the U.S. and get processed at the consulate, or you can get one by being inside of the U.S. and applying for something called adjustment of status. Well, what has happened during COVID, particularly early in COVID, is that those consulates closed down processing of immigrant visas or green cards completely. And they weren't issuing them, or they're issuing them at much smaller rates. So what that means is there's all of these extra green cards that weren't issued outside of the US. If that occurs, they roll in the next fiscal year to the numbers for inside the US. So what we're seeing is that in this current now fiscal year, there are a lot more green cards available for employment-based green cards inside of the US. It's really at the highest number that we've ever seen. So that'll mean a few things. The way that they roll in, just so you know, is it's based on the prioritization within the green card process. So the EB1 is going to be the first category of them that they roll into. And those are your individuals who are extraordinary or who are international managers, those higher level individuals. Then they're going to roll down, if there's still some left, to the EB2 category, which are individuals where it's a higher level position. It requires at least a master's or a bachelor's and 5 years of experience. And then if there's still some left, they're going to roll down into the EB3 category, which is positions that really just require a bachelor's. So professional positions would be how you would define it. And why this is so critical is for certain countries, there is a huge backlog of green cards and availability for green cards. So if someone is from India, it historically may have taken 10 to 15 years for them to get a green card if they're in EB2 or EB3. China, it was probably 5 to 8 years. Certain countries, there's not a wait at all because there aren't as many people trying to enter from those countries. So it really all does depend on demand. But what's going to happen with these extra green cards left over is that they're going to start shortening those wait times, which is very important and very helpful, but it's also going to mean that your employees who are in those long wait categories might now be pushing you more to pursue a green card on their behalf for various reasons. So just be aware that we are seeing that. And, it's something that we're seeing our HR get a lot of pushback on of, I know you didn't need to start my green card for X amount of time, but I think things are going to speed up. I'd like you to start it now. So we are seeing that pushback. Now, one thing that employers can do related to this is there's some strategies you could consider. So first of all, promising green card sponsorship can be a way to recruit and retain talent. Because if you're willing to pursue that green card for them earlier than another company is, and particularly now that there might not be the wait times for some of these individuals that existed before, that might be a way to get people in the door who were not in the door previously. Now, I do want to say one thing to think about with all of these issues with travel and consulate availability would be, we've had a lot of employers come to us and say, well, I really want this person to come to the US, but for whatever reason, whether it's travel ban, they're not willing or able to get vaccinated, whatever the reason is, I can't get them here. I can't even, it's just I can't get them a visa appointment to come over. It's going to be, April until I can get them a visa appointment. We've had some employers say, can they just work remotely? We let all of our employees work remotely now, or we let a large portion of our employees work remotely. Can't I just let them work remotely in their home country, and then when they can come over, they come over? I just want to caution, be aware of this and what it might trigger. It is definitely something you need to look into in detail. So, and what I mean by that is there might be tax implications in the home country. You might trigger employment or labor laws in the home country if you're allowing individuals to work remotely there. So that's just something, I think the gut is, oh yes, we'll go ahead and let them work. Or maybe someone goes over for an appointment and they get stuck there for 6 months. Sure, I don't care if you're working out of your office in Texas or you're working remotely, but there are issues to consider. Are there privacy issues with what they're accessing remotely on their computers? There's a long string of those things that you really need to consider before you answer yes. And I just flag those. There are other people involved in that analysis other than me. I'm the immigration person. I say, hey, heads up, you might want to look at this and you might need to talk to your tax person. You might need to talk to one of our employment attorneys. You might need to talk to an employment attorney in India, to see what laws you are going to trigger, or in Canada, what laws you're going to trigger if you allow them to work remotely. So just a red flag to keep that in mind. All right. That was a lot on travel, and I realize it was really detailed, but I know it's changing regularly, and it's something that I definitely wanted to make certain to cover for everyone. Now I'm just going to go into some of the additional trends that we are seeing and highlight these at a high level from an immigration standpoint. So one is we have seen a continued and expanded I-9 flexibility policy. So it was previously what we saw from the government when COVID started, because keep in mind, I-9s, remember, pre-COVID, you had to review the documents in person. Someone had to review the documents in person to complete the I-9. With COVID, we had all of these companies going to remote work. When the government initially listed the exceptions, they actually said you could only be excluded from the need to do in-person reviews if you actually were completely remote. And I'm going to tell you, there are a lot of companies that while they were remote, they might not have been completely remote. They had people in their mailroom. They had janitorial staff. They had, whatever it might be, facility staff. They had some people on site. And under the original definition, it definitely seemed as though those companies would have to still figure out a way to have in-person review of the I-9s. They did go ahead and loosen that a little bit more. So now it really focuses on the individual. Is the individual going to be completely remote? And if they are, there are exceptions where you don't have to view those documents for the I-9 in person. That being said, I am cautioning my clients because there is going to be a time when you do have to review them in person. So the way that this is phrased is that you don't have to do it now, but then once this situation goes away, meaning once you bring people back, or once the government says, okay, we're no longer going to make these exceptions, what they have said is that, at least as of now, you'll have 3 days to see all of those in person. So going back to what it would have been originally when you hired. So I would just caution, one, you need to be tracking which ones you're seeing in person and not. And then two, when you have the opportunity to see one in person, if the person comes in or, on occasion or something along those lines, you might want to go ahead and take the advantage of that opportunity to review the documents so you're not having to do as many of them down the line. But just keep in mind that will be coming. It might be changed. We don't know what type of exceptions they'll make in the future, but as of right now, that's what they've been saying. So another thing that I want to mention is that lengthy adjudications continue. So for our applications that we are filing with the government, with Immigration Services, we are still seeing them take a long time to process in most cases. So one of those examples particularly is when you file for work authorization of a spouse. So for example, I have an employee, they're in H-1B status, they're in L-1 status. In certain circumstances, those spouses are eligible to work. If you are filing those petitions though, you can only file them 6 months in advance, those extensions, and they are sometimes taking a year or more to process. So what's happening with that is we are definitely seeing that the individuals are having a gap in their employment authorization, where suddenly you have this spouse who's worked for the 2 years they've been here, and now they have to stop working. So a few signs of hope, I will say, related to this. So first of all, long ago, it used to be, and I shouldn't say too long ago, let's say 3 years ago or 4 years ago, they used to adjudicate the H-4 documents with the H-1B, meaning when the H-1B was approved, the H-4 in the H-4 EAD or the L-2 in the L-2 EAD would all be adjudicated at the same time. And you didn't have them separated and them taking, a year to get to the spouse's set. I have seen some come through within the last month where they are batching them again. It is not consistent. So I do not want to suggest that this is an overall government policy or process that they're changing. They have not suggested that, but I have been seeing some of them batched together. When they are batched together, we traditionally see them come through much faster because it's just those spouse ones that end up separated that are on this very long train in terms of the processing. So that is one good thing. Another good thing that we just saw happen, although very limited, there was a lawsuit settlement now, we're probably about 2 to 3 weeks ago, that related to those H-4 and L-2 work authorization. And it may provide more options. So essentially for H-4s, it's going to allow 180 days of continued work authorization as long as the H-4 status is valid. Now, why this is so limited is a lot of times when the spouse is applying for their employment authorization extension, it's because their status is expiring too. So in that situation, this 180 days for the EAD exception probably won't apply. There's some things we might be able to do to work around it, such as have them travel and get the H-4 extension outside of the U.S. and then come and apply for the employment authorization extension. However, with travel issues and consulate issues to get visas, that really may not be feasible. But there could be some strategies. This at least opens the door for a little bit of options. The other thing that we're seeing, and this is specific to the L-2 work authorization, is that this lawsuit also specifically indicated with the L-2 work authorizations that an L-2 should be allowed to work incident to their status, which means if they enter with evidence that they are an L-2 and that they are a spouse, they should be able to be granted work authorization and not have to separately apply for an employment authorization card. The issue I will say is the government doesn't have the things in place to make that happen yet. They're supposed to do it within 120 days, but what that would mean essentially, from what we can tell, is that when an L-2 spouse enters the U.S., they get a document that's called an I-94 card or an I-94 record. That I-94 record is going to have to somehow indicate that they are an L2 spouse and not an L2 child. So right now, the border officials don't do that. Honestly, there's not even a field for that in the I-94. So we don't know exactly how that's going to happen. In fact, CBP reportedly indicated that they don't have a way to make it happen. Now, my guess is the federal judge is not going to accept, oh, it's inconvenient as a reason for not doing it. So I think they're going to have to figure out a workaround. But my point here would be there's hope on the horizon, but we really don't know the details yet. So I'm advising clients still file for those extensions. Don't count on this coming into play and it's going to give your L2 spouse work authorization, because as of right now, we just don't know how that's going to happen. Two other things that I just want to mention quickly in passing before wrapping up. One, as part of COVID, Immigration Service has given us, automatic extensions, let's say. So essentially, for common things like requests for evidence, or let's say a notice of intent to deny, or responses to certain government, requests, essentially, they have now told us that you get an additional 60 days to respond. So it used to be that all RFEs were 87 days, typically, that you would get to respond. Now, that's what the deadline will say, but they've added 60 days to that. They do keep extending that. I think right now it's through maybe February, but that is something where you need to keep an eye on it. Your attorney needs to keep an eye on it, obviously, because it can be beneficial. It is more difficult to gather documents, whether it's because people are remote. You might, in immigration situations, be gathering documents, in my case, from individuals in Brazil who maybe, people were out with COVID, or they just, offices were closed for periods of time. So that extra time helps. So the government has recognized that and been flexible with that. The other thing that we're seeing that I would say has made the largest difference, and this isn't related necessarily to COVID, it was more a change in the administration, but it is something that's relatively more recent, is that they are again giving deference to prior approvals. So there was a period in time where if you filed an extension, every extension was being re-adjudicated as though it was a new petition. So there were risks, and it was happening where you could have gotten an approval before, and now the government was issuing an RFE, and in some cases even issuing a denial, because they were re-adjudicating the entire petition, and they were saying, we don't think this should have been approved the first time. They are now giving deference to those prior petitions. So unless there is something that, is significantly in error in that prior petition, you are going to get, or should get, an approval on the extension. And that has made a big difference. If for nothing else, on processing times of the extensions alone, H4 extensions were taking 10 plus months, or I'm sorry, H1B extensions were taking 10 plus months because they were looking at every single one as though it was brand new. What we're seeing now is those extensions are coming through in maybe 2 months, 3 months, because they're looking at it. As long as it appears to be in line with the prior one and nothing's jumping out on the prior one that was a significant error, they're approving it. So it's eased the processing times, if nothing else. So I know that was a lot and it was quick on a lot of different subjects, but I wanted to give you the highlights of the year from what I would say. I do want to go ahead and give you the CLE tracking code. Again, I think Megan said she'll provide these again, but just wanting to clarify for this last segment, the tracking code is TH128E. Again, that's TH128E. My information is here. If you have any questions or need any help on the immigration front, don't hesitate to reach out. I know I covered things at a high level and there might be some follow-up. Happy to help, and thank you. And we have a I guess we're down to 12-minute break now. I apologize, but look forward to having you back, and we'll continue shortly. Thank you. Yeah, we have. Yeah. How are you? I'm actually really glad to be here today because we've been working from home. I'm actually important. And she thinks it's like, I don't know. She got this shrill word and then in the background I'm like, so I'm really excited to come back. We're kind of using I feel like I've worked more. I think they got more out of me following from home than it does. Like, I can't wait because I don't even stand up and walk it, right? So, I guess, I'm like, there's people I don't even know because I meet them through company events right now. So that's really interesting. How's everything going? I love this thing. I'm sitting really.
We're coming out. He hasn't been a lot of use. 2 years to get it finished.
There's your plan. I mean, I know they have some sort of there's about 2 years. Yeah, that's right. But people were gonna go keep this in line and come back in line when I saw your we don't do much. I know. So that's what I mean. So I'm not gonna sit. So it's the benefit. Messaging my yeah, exactly. I think you'll be accepted. My mom's awesome. Okay. Right, yes. I think that'd be fun too. I don't know if you can stop. No, not there. It's on. Oh, yeah. Okay. I hope you guys will be great. You tested yesterday. Yeah. That's great.
Yeah. Yeah. Yes. Good job. All right, welcome back, everyone. My name is Ricardo Hill, and Keith Spiller and I are going to be talking about some of the updates that the Biden administration that come with the Biden administration regarding some employment issues. Our agenda for today, I'm going to talk about the independent contractor tests and the various levels of how that is analyzed. And Keith will be going into more detail about the PRO Act, the Build Back Better bill, and some NLRB developments. So with the independent contractors test, the key question here that we're considering is, what is the standard to use to evaluate whether an individual is a 1099 contractor or a W-2 employee? That is important for various wage issues, employment law issues, and tax issues. So it's a key factor to consider. How that's done depends on what level we're analyzing it from. So at the federal level, depends on which statutes at play. So if we're considering it under FLSA standards, ADEA standards, Title VII standards, and which party has control of the White House, which we will get into more detail later in the presentation. Also, from a state perspective, different states have different tests in which they analyze the status of either an independent contractor or an employee. So for the purposes of FLSA, the Department of Labor evaluates whether an individual is an employee or independent contractor under the economic realities test. There's no final rule on how this is analyzed. It depends on whether you're looking at it from the Department of Labor standard or the court perspective. But this economic realities test is an overall balancing test of various factors, which are viewed at almost holistically and help to determine determine the status of the individual. So the focus of this test is whether the economic realities, rather than the technical concepts of the parties' relationship, are such that the worker is dependent on the company to which they provide services. So the technical concepts that are not really considered for this analysis include the contractual language, where the work is performed, and some of the other technical, more common law concepts that we'll discuss later are implemented. So for the Department of Labor, from the Department of Labor's perspective, the economic realities test analyzes in a balancing perspective 7 different factors. These factors it's not an exhaustive list, but these are just factors that are considered from the Department of Labor. And they include the extent to which the services rendered are an integral part of the principal's business. So, for example, a landscaping company working for a law firm or accounting firm is more likely to be swayed towards an independent contractor status than an employee status because it is not an integral part of that firm's business. Another factor is the permanency of the relationship. So the more that the relationship sways towards an indefinite period, indicates that that individual is likely on the employee, likely to be considered an employee. The next factor would be the amount of the alleged contractor's investment in the facilities and equipment that that worker is using. Next factor is the nature and degree of control by the principal. So the more that the principal or employer or company has control over that worker's schedule and how that work's being performed, sways towards an employee perspective, as opposed to in a company not having that control, swaying more towards an independent contractor perspective. The alleged contractor's opportunities for profit and loss is the next factor considered here. And what that really goes into is more so the individual's managerial efforts and managerial role and how that affects that individual's opportunity for profit or loss. So that is a little different than working more hours or working at a faster pace contributing to a higher profit. It's more so on that, it's kind of referencing that level of control and the managerial aspects of it. Next factor is the amount of initiative, judgment, or foresight in open market competition with others required for the success of the claimed independent contractor. And like I said, that is more so relates to the dependency on the company for that individual's success. And the last factor of the 7 here is the degree of independent business organization and operation. So the more independent that the individual's operation is, the more likely it'll be considered an independent contractor. Now I went into detail on the Department of Labor's analysis of the economic realities test, because other tests are relatively similar, but they just have a little bit of a different approach. So courts also consider the economic realities test, but they focus on 5 factors instead of the other 7, which are pretty similar. So some of them have some crossover, like the degree of control, the investment in facilities, the worker's opportunity for profit or loss, and the permanency of the relationship. The courts also in the past have considered, and this is based on the United States v. Silk case, but courts have also considered the amount of skill required to perform the work. Independent contractors typically are a specifically trained and skilled profession. So if their work is requiring a certain level of skill, it's more likely to sway towards that independent contractor status, as opposed to something that requires a lot of training and less skill to begin with, swaying towards the employee status. Some other tests that have been considered in establishing whether an individual is an independent contractor or employee is the control test used by the IRS commonly. And that is a 20-factor holistic approach, including a lot of the factors from the Department of Labor and the court's economic realities test. But they also throw in other factors as well, including the flexibility given to the individual, the flexibility of schedule, the demand for full-time work by the company, the method of payment that the company gives to that individual, and whether the work is performed on site or how that level of control is established there. Additionally, there's a common law test, a common law Darden test that is established that is used for other statutes, as we mentioned earlier, that are separate from FLSA, such as Title VII, ADA, ADEA, and ERISA, which focuses on the common law agency principles. So that's analyzed more on a case-by-case basis, focuses on the control as well, like the other two tests referenced earlier. But it also focuses on the ability for the company to assign additional projects to that individual, and just how much discretion that the individual has and how he or she is going to perform the work. The NLRB also uses that same Darden test as previously explained. On the state level, the test for determining an independent contractor can vary under the different employment statutes within each state. So we have states like California, New Jersey, Massachusetts specifically that have adopted the ABC test. Now this test varies from the economic reality test and other tests mentioned earlier because this test presumes that the worker is an employee unless each of the following can be established. So the first factor, that the worker has been and will continue to be free from control or discretion over the performance of their work. The second factor is that the work is either outside of the usual course of business for the company requesting the work or performed outside of any of that company's place of business. And then the third factor is the worker is customarily engaged in independently established trade, occupation, profession, or business. So this test is more likely to sway towards the employee status because it presumes that each individual is an employee unless each of the three are established. So those states, when analyzing this process, the status of the individual, are more likely to sway towards that employee-friendly status. And then there are other states that look at it differently as well. They use state-formulated common law tests, such as Ohio, which look at it from the opposite perspective and presume the worker is a contractor, unless the following factors are established as well. So that looks towards the company's control, so whether the company has behavioral and financial control, and considers the documentation established between the two parties. The differences become very important as the White House gets involved. So with the recent change in administration, the recent change in administration has provided a great example of that. In January of this year, the Trump administration, Department of Labor, issued regulations supporting a business-friendly standard that narrowed the focus of that economic realities test to 5 factors. So these factors are similar to how we discussed earlier: the control, opportunity of profit or loss, amount of skill required, the permanency of the relationship, and whether the work was an integral part of the business. Where this administration differed was it provided more emphasis on the degree of control and the opportunity for profit or loss. The administration called these factors the core factors for the analysis, and essentially, if both of these factors swing on the same side of the pendulum, then the end result is most likely going to be that same analysis. So if you're looking at the nature of degree and control, and that individual has a lot of control over how it's going to perform the work, and that individual also manages other individuals, those both sway on the side of independent contractor. And so that is given a lot of weight, and regardless of what the other factors say, it's still most likely going to be an independent contractor, and vice versa. So this is considered a more employer-friendly analysis. However, in May of 2021, the Biden administration's Department of Labor withdrew that employer-friendly independent contractor rule, but did not implement a new rule yet. So the Department of Labor goes back to that traditional economic realities test to determine that status, which is more of a balancing test, holistic approach that considers all of the factors that we discussed earlier. Additionally, President Biden has publicly supported that ABC test, which was implemented in California, New Jersey, and Massachusetts already, that is more employee friendly, as we said earlier, where the individual is presumed to be an employee unless all three of the other factors are implemented that would change that status. Also, President Biden has proposed a $7.5 billion $7.5 billion in the 2022 budget to boost employee protection specifically, which relates to the misclassification of employees specifically, which relates to this issue, among other things such as safety, wages, and other employment issues. And now Keith will continue on with the presentation and talk about the PRO Act. Thank you.
Good morning, everyone. My name is Keith Spiller, and I'm going to, as Ricardo said, bring home the rest of this presentation talking about a couple of different points. One, the PRO Act, which I think had garnered a fair amount of attention over the last couple of months and throughout 2021. And then we'll pivot and talk a little bit about the National Labor Relations Board and what we expect under President Biden for the newly appointed board. So what is it? First, it's the PRO Act, short for Protecting the Right to Organize. As you might guess from that, it is union-oriented. It certainly was a cornerstone of President Biden's election platform. He very much catered to and attempted to garner the support of the unions. He certainly did that. And I think people have this perception that the PRO Act is really just about sort of helping unions organize. And while that certainly is an important component of what the PRO Act would do, it is much broader. And it's something that we'll take a look at, and it really has applicability potentially to non-union employers in pretty serious ways. Now, the key thing to understand is that it is not law yet. We'll talk through that, and we'll talk through the consensus for whether it will become law or not. And as you will see, the fact that it hasn't quite yet become law doesn't mean that there aren't other ways around that, and we'll address those in a bit. So I tried to, in analyzing the bill, it is quite lengthy. It covers a lot of ground. And so what I tried to do was organize this into sort of 8 different buckets or key provisions. As Ricardo talked about just a moment ago, you'll see the first one is the ABC test. And that, as Ricardo said, is employee friendly. It started in California, as all fantastic employment related things do, and moved to the rest of us. It really, and if you think about it in this way, you'll understand the context of the unions, right? Because what this test does is make more contractors employees. And that obviously means more money from an IRS standpoint from withholdings, but it also means that more employees will be covered by the National Labor Relations Act, and therefore there will be more union members if there is organizing going on. So that's the connectivity that we have from a union standpoint. Number 2, same concept here. As opposed to contractors, we're redefining what a supervisor is. Under Section 211 of the National Labor Relations Act, supervisors are excluded from being part of unions. What this provision of the PRO Act would do would be to, in essence, modify or tighten the definition of supervisors so that more supervisors previously classified would be classified as employees. Same concept, more potential revenue, and then more potential union members. So these are the kind of quasi-supervisors who maybe sometimes would certainly, play the role on the floor as a supervisor, but also perform production work. This would tighten that definition down quite significantly. Expand union organizing rights. As you would guess from the title, this is a key part of the PRO Act. So a couple things that are really, I think, interesting and important. So the first one is employees would have the right to use the company email to organize. I'll say that again. Employees would have, and the union would have the right to have the employees internally who are supporting the union use the company email system. No more on-the-clock meetings about unions. So this has been a traditional weapon that employers have used over the last 100 years. They bring their folks in, they pay for the meeting, they tell the employees why they shouldn't join a union. The PRO Act would say, you can't do that anymore. That's a critical piece of our weaponry in staving off union organizing campaigns. Number 3, mandates the disclosure of employee contact information to the unions in advance of the election. At some point, we have to do what's called an Excelsior list, which we give the board the list of employees who are going to be eligible to vote. This is more than that. This is contact information on their emails, their cell phones, their address, allows them to contact them directly. Number 4, allow union votes away from the premises. So in other words, the election will be conducted by mail. We've seen some of that during COVID. This would formalize that. Also electronically, where you could vote via a website or an app. And if you think current elections are fraught with peril, as we learned with the most recent situation with Amazon, my gosh, doing it electronically is scarier indeed. Number 5, prohibits employees from participating in employers, actually that should say, from participating in rep hearings. And this hearing is the hearing in which the employer participates in now under board law, and it's determined what the scope of the bargaining unit is going to be. Because when the union petitions for an election, they say, I want to represent these employees. The employer has a say, and we actually participate in that rep hearing and say, here, we think the scope of the union should be this. And this PRO Act would preclude the employers from actually doing that. Quicker elections, 21 days, not 41. That's from the petition filing until the actual election has occurred, basically cutting the time we have to communicate with our workers about why not to join a union in half. Significant. And also allow for micro units. And what that means is it gives, if a union is trying to organize a larger unit and they're not having success, they can chop that unit up into smaller groups where they think they might have more votes and use that as the petition to file the election for, as opposed to the larger unit. So it kind of gives them the ability to sort of slice and dice the workforce in a way that will benefit the union. So lots of stuff there. Number 4 is elimination of right to work states. In 27 states across the US, and there are various ways this comes to fruition, but in essence, what the PRO Act would do would be to say, look, if you're in a collective bargaining agreement, if your employer has one and you're part of that bargaining unit, you have to become a member of the union and you have to pay union fees and dues. In 27 states, including in Kentucky, that right to not join the union and or right not to pay dues or union fees, that right exists. That's the concept behind right to work states. The PRO Act would eliminate those across the board. Number 5, collective bargaining changes. This is also pretty scary. I'll be honest with you. If a union comes in essence, you begin negotiations. And those negotiations, because you're literally negotiating every word in that collective bargaining agreement, they take forever. I've been doing this for 32 years. Rarely does the first collective bargaining agreement get negotiated in 120 days. It takes longer than that. What the PRO Act would say is in this circumstance where you don't get a contract within 120 days of the union being certified, then there's going to be a mandated interest arbitration where likely 3 people who have no connection to your business, who don't understand your workers, who don't understand your finances, will come in and dictate what that contract is. That's pretty scary stuff. Other scary stuff, unions can demand that the company does not do business with non-union companies. They are dictating who you do business with. That obviously can take out a huge segment of certain populations depending on what industry you're in. That could be a real problem. And then lastly, the PRO Act prohibits the unilateral implementation of LBF, which is last, best, and final. So once the parties in negotiation reach an impasse, we're stuck on our position, the union's stuck on theirs. The employer can implement its last, best, and final offer. Then the union can decide whether to sort of take that or go out on strike. We would not be able to do that from an employer standpoint. We would have to keep the status quo, whatever that is. So again, we lose part of our arrows from our quiver in terms of being able to effectively deal with union negotiations. 6, strikes and picketing. 1933, the board has allowed employers to permanently replace an economic striker. If I go out on strike because of money or benefits, I have the right as the employer to replace that employee. The PRO Act would outlaw that. The PRO Act would allow employees, if they were upset over changes in policy, changes in machinery, whatever, to do slowdown strikes, to do intermittent strikes, to do partial strikes. Again, pretty scary stuff in the days of COVID. It would also outlaw offensive lockouts. And this is a circumstance where we think the union is going on strike, so we as a company decide to put pressure on them from a bargaining standpoint by, in effect, locking the plant and not letting them in. So it's the opposite of a strike. We withhold the ability for them to perform labor. We would lose that ability, which has been in place since 1965. And lastly, allow secondary boycotts by the unions. The unions could picket neutrals such as your customers or your suppliers. If they were upset with something you did, they have the ability to go to your customer's workplace and put a picket up publicizing the stuff that you allege to have done versus the union. Again, scary stuff. And this really gets to, and this I think is what makes us so queasy about this, this really gets to the relationship, not just between employees and employer, but between an employer and the employer's business, their customers, their suppliers. It really can impact things, I think, well beyond what the National Labor Relations Act would, and perhaps editorially speaking here, should address. 7, a lot of increased penalties. Right now, the NLRB has sort of limited penalties available to it. This would beef up the financial penalties if an employer violates the National Labor Relations Act. Also, interestingly, for you officials or officers and directors out there, there would be potential individual liability associated with violations of the National Labor Relations Act on you. And then also a private right of action under 8A1 and 8A3 of the Act, which means now you have to file a charge with the board. Now, under the PRO Act, you would be able to, in essence, file a suit in federal court and say my employer violated the National Labor Relations Act and did so in these ways, which is, again, not something that is available to an employee these days. And then lastly, just some miscellaneous stuff. Right now, employers can mandate arbitration in many states that sort of waive the ability to bring a class action. Some employers have taken advantage of that. There are certainly state laws that impact that, including California. The PRO Act would outlaw that ability. Secondarily, there are new persuader rules. And what a persuader is if in a union campaign, many times an employer will hire an employee in a business that will come in and help them defeat the union. Many times they will hire us. It's what we do. We deal in campaigns and help, the messaging and how to respond to a union campaign. What the PRO Act would say is the employer would be required to disclose the financial arrangement that it has with those companies that help them deal with the union, including their law firms. So they would have to reveal how much they pay us, our hourly rates, what our fees are, all of those things that employers simply have never had to disclose in the past. And then lastly, NLRB orders would become self-enforcing. And what that means is today, when the NLRB says, okay, you have to pay X, or you have to post this notice, or you have to take these remedial steps to remedy a violation, the board can't enforce those themselves. They have no mechanism to do that. And so if a board wants to force an employer who is recalcitrant about an order, what they do is they have to go file in federal court in one of the 6 circuits or one of the circuits to enforce their orders. And that's obviously sometimes results in a defeat by the NLRB by the court. And they say, no, we're not going to force the employer to do that. The PRO Act would basically give the NLRB the right to enforce their own orders, which is a big deal for them and something they've never had and always wanted. So, this is scary stuff. And as I said in the first slide, this is not law yet, okay? So let's talk about the status, because I think that's important to understand where we are. So it was introduced in February of this year in both the House and the Senate, okay? On March 9th, it passed the House, 225 to 206, largely party lines, to no one's surprise. And now it is in the Senate, and it's stuck in the Senate. And the interesting part about that is President Biden has said, look, I'm going to sign this the first moment it hits my desk, because I have promised the unions that I'm going to deliver this for them. His problem is he can't get it out of the Senate, right? If you've been following this, and you probably should be if you're in the HR arena, certainly. If you're following this, you know that there's been a lot of discussion about the filibuster. And obviously the filibuster requires to break a Republican filibuster. So let's say, for instance, that this bill came to the floor somehow, right, in the Senate. What's going to happen is the Republicans are going to filibuster. And the Democrats need 60 out of the 100 votes to break that filibuster and bring it to the floor for a vote. They can't get that right now. So right now, that's the problem. As we'll see in a moment, there have been ways that the Democrats are trying to get around this potential issue, and I'll share with you how they're trying to do that in a moment. But first, I wanted to raise these 2 people to you. These folks are important. If you don't know who they are, you should. The gentleman on the left is Joe Manchin. He's a senator from West Virginia. The woman on the right is Kristen Sinema, who's a Democratic senator from Arizona. Manchin is a Democrat as well. They're pretty moderate Democrats from a political standpoint. They often don't vote in line with the Democrats. These 2 folks are really important because these are very pivotal votes in terms of the PRO Act, in terms of the filibuster. Manchin has sort of seen a lot of press lately because, as we'll talk about in a minute with the Build Back Better Act, he's a key person in the Senate because he doesn't vote. He votes how he wants to vote, not necessarily with a party line. So interestingly, he has been his financial coffers in the last year have been incredibly increased. So in 2021, he has received $3.3 million in contributions, okay, which is 14 times what he got last year at this time. So what that tells you is a lot of people are trying to gain favor with Joe, okay? what tells you is how important he and Senator Sinema are to everybody, to the Democrats, to the Republicans, to the middle, to everybody, because these folks are the fulcrum. These folks are the ones who are really determining what happens, what gets in bills that are union and employer related. Because remember, what's happening here and what will happen for the rest of the Biden term is they're going to try to pass employee-friendly legislation, okay? The PRO Act is one of those. The Build Better Act is another. So let's talk about that a little bit. So if you've heard those terms or that term, what it is 2,400 pages of social spending and climate goals. And what's been interesting is we've watched the infrastructure bill come through and get passed. We've watched the Build Back Better Act come up, and we've seen it change over time. In the beginning, there were a lot of employee-friendly parts of the build of the BBB, okay? The PRO Act was in there originally, or many aspects of the PRO Act. As we have progressed in committee deliberations and Senate deliberations, most of the PRO Act stuff, the 8 buckets I just covered, have been sort of winnowed out of the BBB. What remains, though, are those penalties, okay? The penalties we talked about for employers who violate the National Labor Relations Act. They're still in there. And it's interesting, you know, how they've gotten around this is they've said, well, we're going to, by these increased penalties, we're going to create more money. We're going to create more revenue. And we estimate that if we do this right, we're going to take $2.76 billion from employers over the next 10 years through these enhanced penalties and like the stuff like Ricardo talked about with misclassification of independent contractors. We're going to fund this through $2.76 billion, taking that from employers. And it really, as somebody said, and I think this is exactly right, it converts the National Labor Relations Act from okay, you know, we're going to make whole to one that give employers the potential for getting serious punitive damages awarded as a result of that. So that's what we're seeing. So pay attention to the Build Better Act. There's a lot going on with like FMLA. There began with 12 weeks of paid leave, I think. Manchin sort of beat his chest. That is now, I think, down to 4 weeks of paid FMLA leave or paid family and medical leave act, depending on, there's some differences as I understand it. So pay attention to those things because, you know, those, as the BBB gets through, what it will contain and not contain will impact, obviously, your business. So just on that, it did pass the House in November. Again, pretty close to party lines. Schumer has said that he plans on bringing this to the floor of the Senate next week. So stuff to look at. And yeah, here's the 4 weeks of government paid FMLA leave. So we'll see what transpires on that. Yeah, just a little more on the BBB as well. So I want to spend the last couple of moments talking about the National Labor Relations Board. This is just so you understand and everybody has the foundational knowledge here. The NLRB is typically a 5-person body that makes decisions on the National Labor Relations Act interpretation. And most people think, I don't have a union. That doesn't matter to me as a business. And it's not quite that clear. And we learned that during the Obama administration, where the board, and again, the NLRB typically, it's very political, right? Because there are 3 folks on the board out of 5 who are appointed by the majority party of the president. So the political views of the board, the 3 versus the 2, swings depending on who's in office, right? So we saw during the Obama administration a lot of decisions, like, for instance, that really limited what and restricted what an employer could put in their handbook. So there were rules about social media. All those things we really talked to you all and talked to our clients about. How do we deal with those changes? And they were, again, very pro-employee. Trump obviously came in, got to appoint the 3, we saw a switch back and a move back from a lot of those Obama board-based decisions, became more employer friendly. And obviously now that we've got a newly constituted board since August, we've got 3 Democrats on it with 2 Republicans. And it's interesting, the 2 Democrats that were appointed, 1 remained, the 2 that were appointed were both SEIU lawyers, so service employees, union lawyers, and they now constitute the Democratic majority. So we are expecting a return to the Obama board rulings and rules very similar in nature to what we saw during his presidency. Interestingly, Biden fired the general counsel of the NLRB, and that's something that usually doesn't happen when an incoming president comes in. But in this case, Biden decided to give that person their walking papers, and they now have a CWA, Communication Workers Union lawyer, as the new board general counsel. So, we've got a very union-oriented board, which is certainly accepted. It's something that we expected, certainly something that we had during the Obama administration. So, again, we'd expect some continuity there between how his board acted and how President Biden's board acted. So 3 agenda items for the new board. I mentioned some of this. We would expect the board to be very focused on overturning a lot of the precedent that were set over the last 4 years during the Trump administration. Basically, Trump's board, as you might expect, gutted the Obama handbook cases. So we really didn't have to worry about the NLRA when we were drafting our handbooks. We're going to have to come back to that and look at the Obama type changes that we would expect. Nothing's been issued yet, but we certainly expect to see that. We expect to see some new prohibitions on the confidentiality provisions that we have in separation agreements. Again, remember, this is the NLRB, and you think that this is only union issues, but as you can see here, these first 3 precedent that we expect to be overturned don't have anything to do with unions. These are employees and applicable to everybody, whether you have a union or not. So there's been a lot of issues with the confidentiality on, like, sexual harassment claims. New York certainly has that, where the board is expected to weigh into that. The new board is. Scope of protected and concerted activity. So this is an important issue these days, especially in COVID, right, where you've got a lot of employee activists who feel strongly about their positions on COVID, vaccines, masks, mandates, you name it. A lot of people feel strongly about it. This would broaden, again, we would expect the Biden board to broaden the scope of what is protected concerted activity. If it's protected and concerted, the employee can do it in the workplace without fear of being disciplined by the employer. And then lastly, union access. And the Trump board, in essence, really tried to make it more difficult for organizers to gain access to a property of an employer. And whether it was emails or something else, physical presence as well, we would expect the Trump, many of those type of access decisions to get overruled. 2 other points here, key subjects that the new board is going to be interested in, and then case handling matters. So the wine garden rights, many of you know that term. In essence, what that means is if you're going to investigate, if you're going to discipline folks, the employees have the right to have someone else, their union rep, there during the investigation meeting if it's going to lead to discipline. That's the essence of the wine garden rights under the National Labor Relations Act. We would expect that to be broadened by the Biden board. This is something that the new general counsel has articulated as a subject that they're very interested in pursuing. So we would expect to see changes to that. We'd expect to see changes to the duty to recognize and bargain. And then lastly, from a case handling matter, and what I mean by that is the board will change how it handles the cases that come before it. 10J is a section of the National Labor Relations Act that gives the board the ability to seek an injunction to stop something from happening or to mandate an employer to do something. The board very much wants to use that. It's used very sparingly now, only in really horrific situations. The board, the Biden board, very much is focused on expanding the use of 10J injunctive relief. And then lastly, partial lockouts. They're very focused on making sure that the employer cannot do that, cannot have a partial lockout where we talked about that before, where they're putting a padlock on the plant, limiting that as well. So looks like we're right at noon, which is good. So the tracking code for this segment is TH128B. I'll say it again. The tracking code for this segment is TH, all caps, 128B, as in boy, all caps for that. Thank you very much, and we'll go on break for lunch until 12:45. Thank you very much.
Okay. All right, good afternoon, everyone. We are returning again from our lunch break. Welcome back. Welcome to all you virtually. We're going to get started again with the new world of non-compete and trade secret law post-COVID. To quote a seasonal, or to paraphrase a seasonal song that's popular, it's beginning to look a lot like California in the rest of the country with regard to non-competes in the last few months and year. We're seeing that there is increasing legislation, state and local legislation, that is tightening up an employer's ability to enact non-compete agreements with their employees. Some new laws are either forbidding them, many are significantly restricting them, or at least placing some parameters on when those non-competes can be used. Some states, again, do prohibit or nearly prohibit those non-competes. We're all aware of California. In fact, I think if you utter the words non-compete in California, you might spontaneously combust. But in addition to California, North Carolina and Oklahoma are also on that list of states now really forbidding the use of non-compete agreements with their employees. And we've seen a number of localities and states joining these ranks of offering restrictions with regard to non-competes. New to the party this year was the District of Columbia, with some fairly controversial legislation that applies not only after employment, but during an employee's employment. So in DC, it is forbidden to have a non-compete that restricts an employer's employee from competing against the employer while still getting paid by the employer and being on the payroll. This applies to DC-based companies and also to all employees who perform work in DC. So even if you are not in DC, if you have employees who work there, you're subject to this coverage. It prohibits retaliation. It requires certain notice provisions, and it allows for financial penalties for employers who dare to try to use non-competes within the District of Columbia. Other recent legislation by the states include Oregon and Nevada, a couple of other states that we'll look at in a few minutes, In Oregon, there was some refining of existing legislation that went from an 18-month maximum on non-competes to a 12-month. And Oregon is among those ranks of states that are starting to only permit non-competes based upon a salary threshold. In Oregon, the statute says it's limited to employees who earn more than $100,533. Why the $533 was added on there, I have no idea, but that is the threshold. Under that threshold, you cannot use non-competes in Oregon. The employer also must pay the former employee during the restricted period, so it's starting to look like the European model of a garden type leave. In Nevada, non-competes are now prohibited for hourly employees, and Nevada limits the ability to restrict a former employee from providing services to the employer's customers or clients. So you can't have a general non-compete in Nevada. It has to be tailored to protecting the particular services or clients that the employee dealt with while employed by the company. Other recent legislation includes Illinois, Maryland, and Virginia. And again, this common theme that you're seeing a salary threshold under which non-competes are prohibited. Some of these states also have a threshold for non-solicitation agreements. Some of them do not. Some of them are building in automatic periodic increases for several years so that threshold is going to continue to bump up and up. In Virginia, non-competes are prohibited for quote-unquote low-wage employees, and instead of providing an exact salary, they give this calculation based upon the average weekly pay in the state of Virginia. And the legislation also expressly prohibits the use of non-competes in certain employment areas and certain specific jobs. What we're also seeing is a increasing debate about choice of law provisions. So when we're drafting non-compete agreements for companies that have multi-state operations, choice of law becomes very important because typically you want to have a choice of law provision identifying the state that the company is based in, especially if that's a favorable state like Ohio with regard to non-compete law. But there are an increasing number of states and circuits that are really taking a look at this. Some are continuing to uphold those choice of law provisions. We've seen that in the last few months. But we're also seeing some circuits and some judges strike down these choice of law provisions and saying, nope, you have to use the law of the state in which the employee is employed. So that's another thing that really needs to be evaluated. We also, of course, there was a great to-do a few months ago about President Biden's executive order encouraging the Federal Trade Commission to also consider regulations that would either curtail the use of non-competes or restrict the use of non-competes and analyze whether those agreements unfairly limit worker mobility. This was not a surprise. It's something that President Biden talked about on the campaign trail. It's something that Congress had looked at a couple of times, but never really gotten traction from a legislative standpoint. But now he's encouraged the FTC to take a look at such regulations. Of course, there are a lot of questions that surround this. Foremost, will the FTC actually act on this? It doesn't order the FTC to take action. It encourages the FTC to take action. There's also a question, of course, about what would those regulations look like? Would it completely eliminate the use of non-competes, which does not seem likely? Would it address non-solicitation agreements as well as non-competes? And how would the enforcement mechanism work? We did see a little bit of a preview about what the FTC might be looking at because about a year ago, it did conduct a workshop on possible rulemaking regarding the use of non-competes. That was pre-executive order. And the things that the FTC took comment on during that workshop was really looking at the impact of non-competes on labor market participants. What happens to mobility? What are the business justifications for non-compete clauses? We all know them as employers and companies, but the FTC took comment on why do businesses need non-compete agreements with especially their key employees. Other comments that were invited were, is state law sufficient to address harms associated with non-compete clauses? Are there situations where non-compete clauses can create an unfair situation, an unfair method of competition, for instance? and should the FTC actually consider its rulemaking authority. So the bottom line with regard to non-competes post-COVID certainly is, let's stay tuned. We've seen this increase in legislation. I think we are likely to see continuing legislation into 2022, perhaps federal legislation. What should you do as an employer? What you should be doing right now is really taking stock of what kind of agreements you do have in place with your employees. Most times, these new pieces of legislation are not retroactive. So if you have non-compete agreements, you should be making sure that they are in good shape, that you have them with key employees if you don't already have them, and that you make sure that they are, that everybody takes notice of them. If you don't have non-competes with folks that you should, now is a good time to make sure you do implement them. And you also need to conduct a little bit of an audit if you're a multi-state employer and make sure that you are complying with these additional rules and requirements in the various cities and states that you may operate in. And this is not a stagnant event. This is much like job descriptions that should be looked at periodically. Your non-competes, your non-solicitation agreements are agreements that, especially in light of the current traction, that you should be looking at on a periodic basis, evaluating, updating, changing, and making sure that you do have a point person that is staying in tune with the changes and what you should be doing to address them. The hand in hand with trade secrets, of course, is the protection, with non-competes, is the protection of trade secrets. Very often, the folks that you have signed up to non-compete agreements are also privy to your trade secret information. And you can use common law trade secret principles to protect that, even separate and apart from a non-compete agreement. But the other thing that has changed and related to COVID is how you must go about protecting your trade secrets. So first of all, to have trade secret information and to be able to protect it, it has to be information, processes, methods, procedures, etc., that you have invested time and resources in that provide an economic advantage and that would provide an unfair competitive advantage to your competitors if they were to gain access to them. But also to avail yourself of the ability to protect those trade secrets and take on an enforcement action is you have to show that you've taken reasonable steps to protect the integrity of that trade secret information. We used to know what that meant. It meant things like making sure that your computer systems are password protected, like limiting information to those who have a need to know it, stamping documents as confidential, making sure that you have visitors escorted through your organization if they arrive. But what are reasonable efforts in the age of COVID? That's changed a bit. And this all came screaming to light for us with a case out of Delaware from August of 2020 called Smash Franchise Partners versus Kanda Holdings, Inc. And this was a case, Smash Franchise Partners is a company that does trash compacting and hauling away that trash. And it was a company that has franchisees and was looking to recruit more franchisees to its organization. There were a couple of folks who represented that they were interested in becoming a franchisee, and they participated in certain meetings with Smash Franchise Partners in order to obtain information. And what happened, of course, is they weren't interested in becoming franchisees at all. They were interested in starting a competing company, which they did. Smash Franchise went on to file an enforcement action against these folks, alleging, among other things, misappropriation of trade secrets and sought to shut them down. And the court refused to grant the injunctive relief requested, in part due to a Zoom call. So what happened is that there were these various Zoom calls set up to provide information to the prospective franchisees. And the court found that there were not reasonable steps taken during those calls to protect the trade secret information that was freely shared during these Zoom calls. The information on the calls was freely provided to anyone who had expressed interest in a franchise and completed an introductory call. There were no NDAs or other vetting of these folks. There was no protection against people then providing the contact information on to other folks. The court found that the plaintiff did not require a participant password, and in fact did not even follow the procedures that Zoom allows with regard to screening participants in the waiting room. And the company didn't take advantage of its own procedures too, to take a roll call at the beginning, to ask that anybody who was not specifically authorized or announced to remove themselves from the meeting. So based upon that, the court, that was one of the reasons that the court said no injunctive relief, you didn't protect your trade secret informations. So some big lessons here for companies moving forward about what should you be doing in this new post-COVID world. Certainly the lesson in this particular case was make sure when you're using these web-based platforms for meetings that you're thinking about security and that you're following not only your own protocol, but the security protocol provided by these various platforms. And make sure that you are providing training to everyone who's using these platforms, whether it's your sales reps, your supervisors, your management team. Anytime there are interfaces with outside parties and sensitive information is being shared, there needs to be a heightened sensitivity to the security surrounding these web-based get-togethers as well. So the Smash case really does provide this grave illustration that perhaps what we thought used to be reasonable to protect your trade secrets may not be considered to be reasonable steps in this particular new reality. And let's face it, what we're beginning to see is this is not just something, the new way we work is not just part of the COVID protocol. We really are seeing signs that remote work is going to be part of the new reality for a lot of employers. Most employees expect to be able to continue to have some flexibility. A lot of employers are reporting that they're continuing to utilize flexibility, both because they've seen that it can be productive and because it's a retention issue now for many current employees and a recruiting issue for prospective employees. And there are some concerns associated. I think many companies are now coming up to speed with making sure folks are set up in their remote locations. They have the proper equipment and are doing what they need to do. But at least initially, 8 out of 10 employers who are allowing remote work didn't provide the actual tools or resources for the employees to work remotely. So we had a lot of folks who were using their own private devices to be able to perform the work for their companies at home. I'm seeing that my screen is frozen. I hope that it will unfreeze in a minute and that you're all able to still follow along here. But just the fact that we are having this increased work remote situation does create some risks to the integrity of your trade secrets, a lot of various risks. There are increased risks with regard to hacking. You're not in the confines of an office environment that provides the protections that your IT department sets up, so the devices are more vulnerable to potential hacks. Think about how trade secrets are handled when somebody is working remotely. So they're dealing with documentation. They have a lot of your, they might have your formulas or your strategic information or your sales documents. How are they being handled? What happens to them when they're finished using those documents? Are they putting those documents into their trash can at home? Are they putting them into the trash can at Starbucks where they might be working in the afternoon? How are those documents being handled? Is there a cross-mingling of personal devices and proprietary information? So if someone has a laptop, but they might also have their home computer, maybe they choose to work for their home computer and they're mixing, they're downloading information, they're using the remote access from their personal devices to get your information. That's something that should be of concern to you and decide how to handle that. There could be inadvertent disclosure to household members or to third parties. So many folks were in a situation where their roommates, their spouses, their partners were also working from home. Maybe their adult children were also working from the same place. Maybe they are going to Starbucks or those kinds of things and working remotely where there are other folks involved. And if it can be shown that those third parties might overhear conversations or be exposed to the trade secret information, that can impact your ability to indicate, to represent that you're adequately protecting the integrity of that trade secret information. Also increased risks of phishing and spam operations, all things that you need to be aware of. So what should you be doing to protect against these increased risks to you? First of all, some things haven't changed. You should still be doing the basics. Make sure that you are properly identifying trade secret information for your employees. You ought to be identifying that yourself and making sure employees understand what do you consider to be your trade secret information. It can be set forth in those agreements you have with employees. Even if you can't use a non-compete, you can still use confidentiality agreements. Make sure that you're not using an exhaustive list, but a representative list of the types of information that you consider to be trade secret. Continue to limit access to information to those truly who have the need to know it. Use those computer passwords and secure logins. Stratify your database so that only certain people can access information that's sensitive. Use your firewalls, security software, and more companies are moving toward using some type of encryption as well, particularly for their sensitive information. Those are all things that we were used to doing, and those things absolutely have not changed. But you need to do some additional things as you continue to have employees working from home. First of all, you can and you should certainly address their home security measures. So you should have policies in place that set forth what your expectations are as an employer for what the employee should have at home in order for them to be able to work remotely. So set forth those standards where you require minimum home security measures if they are going to be performing work from home. Make sure there are Wi-Fi passwords and limitations in place with regard to those. And if you don't already have it, consider things like multi-factor authentication in order to log on to a company portal. Certainly make sure your policies are up to date about the use of devices and whether you're going to allow those personal devices to be used or how they should be restricted. Require that employees are using antivirus software. Again, particularly if you are permitting some personal devices to be used, you should at least set the standard for what type of antivirus software should be installed and maintained on those devices so that you can protect more against those scam operations out there that are always on the rise. Make sure that you are reevaluating this need to know basis. Are you really properly limiting access to information? Because if people are remote and they're downloading this information, nobody's going to be in the next cubicle or the next office or stepping into their office to oversee what they're accessing. There's not that same risk of being caught, if you will, that may keep employees on their toes. So make sure you're really evaluating, who needs to access these certain files. Add additional credentialing for downloading information and, restrict the ability to download that information to non-company devices. Make that part of your policy. Restrict not only personal devices, but really look at your policy on the use of portable electronic devices. Are you going to allow them? If so, make sure you have very clear restrictions on when they can be used. Perhaps you only allow employees to use company-issued devices, make them report what those devices are, what the uses are, perhaps require an inspection on a periodic time, or consider blocking USB ports if you don't want employees using portable electronic devices that they can then use also with their personal devices. Consider these things, train your employees on them, and incorporate them into your policies. With regard to those personal devices, if you are going to allow the use of them, again, make sure you're using that baseline security, require updates periodically, set up and utilize remote wiping technology. Make sure that employees are aware of that you can remotely wipe data that they may have on these devices should they choose to use them. And really, if they are having a company-issued device, you should prohibit the transfer of trade secret information onto any personal device, absent some very express authorization. Maybe there's a particular circumstance, their company device isn't working, they're getting an update, something, but your trade secret device material should not be just allowed to be used willy-nilly with the employee's personal devices. Something else employers could and really should consider in this new remote work reality is updating their monitoring policies and use them. There are a few different types of monitoring that employers can be doing to make sure that they are protecting prospectively their trade secret information. One is just routine monitoring. Set up so every now and then IT is taking a look at sort of like random drug tests, that you're taking a look at a user, what documents are they accessing, what have they downloaded recently, what have they modified, what's the email activity, just on a routine basis that you're doing that. Obviously make sure your policies advise your employees that they are subject to monitoring, and make sure that they know that you're actively doing that. You can also set up some suspicious use monitoring. So you can have flags put into place electronically that if there is a large amount of data, for instance, accessed within a short period of time, a large amount of documents that are downloaded or printed or transferred within a short period of time, that sends a red flag to your IT department to take a look. Is this a legitimate business reason? Do they have a big project that they're reasonably using these documents to prepare for? Or is there some reason? And especially important now when we see, there's so many jobs available, so much flexibility for employees now. Folks should always be concerned that people are looking for their next gig, and make sure that you're looking for, are they taking your materials with them when they're looking for that? Another type of monitoring that you can establish is key data monitoring. So whenever certain critical documents are touched by anyone, someone gets notice of that. And again, you can take a look at, should they be accessing it? Should they not? And take steps from there. Also, renewed training is really a key right now. So make sure as you're updating these remote work policies that you're renewing your training with individuals. So you're not just doing your end of year EEO training, but you're doing some trade secret training as well, so that folks know, what are your trade secrets? What do you expect of them? What have you added and enhanced to accommodate remote work situations? And what are their expectations? Make sure you have written policies, that you keep copies of your training materials. These are all things you can use should it become necessary in an enforcement action to demonstrate that you've taken steps to protect that information from being misappropriated. Also, really reevaluate how you're handling departing or furloughed employees. So again, we continue, there's a lot of flexibility, a lot of mobility. Certainly for departing employees, make sure you're cutting off access immediately, that you're conducting exit interviews, even if you're doing them remotely, that you're requiring the immediate return of equipment. What we've seen too often in the last many months is that someone may be remote, they're exiting the company, they've been working remotely for a period of time, and maybe they take a couple of weeks or a month to return their device and have been doing who knows what with it in the meantime. What you should do for any exiting employee is make sure, if they're not in a city where you can send someone to pick up the information, is FedEx them a FedEx box to return to you the next day, and make sure that equipment is in there. For furloughed employees, make sure that you emphasize the directive not to work during the furlough period, and consider retrieving all their devices during that period of time as well, so that you, again, cut off access to your sensitive information during that period of time that they should not be performing work for you. Moving beyond trade secret protections, I just want to spend a few minutes touching on a couple of other developments in the world of trade secrets. First of all, this year was the 5-year anniversary of the Defend Trade Secrets Act. And there were really 3 goals of this statute originally. It was to create a federal civil remedy so that owners of trade secrets could go to federal court to get action, to promote uniformity among state laws, and to better address the concerns of this globalized economy, where you may have folks that are going beyond the borders with your trade secret information. What we have seen is that there's been about a 30% increase in trade secret filings in federal court. I will say I've been a large part of that. People who do a lot of litigation with regard to non-competes really welcomed the ability to go into federal court when you're in jurisdictions where the state court bench may not have a lot of experience with these issues, or may not be inclined to enforce them. And so we really have seen an increase in trade secrets filings on the federal level. With regard to the uniformity goal, though, really not so much. I mean, really what we've seen is the federal courts pretty much follow the law of the state. So we've still seen that sort of fractures of enforcement in terms of following what the state law had always been. With regard to the third goal, we have seen that there had been willingness to use this arm to be able to protect trade secrets on an extraterritorial basis, where the offender is a citizen or permanent resident of the U.S., or where the act in furtherance of the offense was committed in the U.S. So this has been a big development in the last few years, and it has really proven to be a good tool for employers and their counsel to utilize. Another thing that's been a debate in recent months in the world of trade secrets is what level of specificity should be pled in a trade secret case. There's always this balance between employers who seek an enforcement action with, well, how much do I have to put out there? How much do I need to put in the pleadings? How much do I need to tell the party that I'm bringing this suit against, because I don't want them to know my trade secret information? And that's balanced against the fact that judges are looking at these things and saying, well, hey, you got to give folks, some reason and some reasonable means to understand what your issue is here. So there's been a lot of litigation about that. There's been something called the Sedona Conference that's looked at proposing guiding principles for when you should be required to identify the alleged trade secrets. And some of those principles that are developing is that, look, it doesn't necessarily have to be set forth in the complaint, but it should be provided in the discovery stages. If you're going to claim trade secrets, you're going to have to provide some type of information to that party on the other side about what you're seeking to prevent and why it is that it's a trade secret. So another thing in the coming months to keep your eye on, another thing to have those debates about when you're filing trade secret claims, about how much is too much and how much is not enough, always a balancing act. And with that, I thank you for your time, and I am going to turn the podium over to Laura Ryan and Kim Wilcoxon to talk about hot topics in employee benefits. I know they both have a lot of information to share with you this afternoon as well. And certainly if you all who are remote have any questions about my presentation, feel free to forward them and we will address them as best we can. Thanks so much.
Okay, thanks, Debbie. There we go. All right, well, thank you very much. We are pleased to be able to present some information and updates in the area of employee benefits as part of this labor and employment program. I know you heard a few updates from my colleague Beth Mandel earlier today on all things vaccine related and COVID testing related and some of the employee benefit implications associated with those mandates and requirements. Today we're going to focus on, Kim and I are going to focus on things other than vaccines. And I'm going to start with some of the retirement plan related hot topics. These are items that really I'm counseling my clients on right now. They're also items that my clients are calling me as they're wrestling with issues in this area. So it's a little bit of a grab bag of items. The first topic that I wanted to highlight is cybersecurity. And back in April, we got from the Department of Labor some long-awaited guidance on cybersecurity and retirement plans. So I heard some references by Debbie to security measures. You know, obviously those were geared towards companies ensuring they're protecting their confidential information. These are more focused on fiduciaries with respect to retirement plans and making sure that fiduciaries are doing what they should be doing and can do to secure retirement plan accounts from, you know, cybersecurity, breaches, fraud, etc.
And I use the term guidance, although I use that very loosely. This is not guidance in the form of formal rules and regulations. It is guidance in the form of what the Department of Labor views as best practices in this area. And it was done merely through a post to their website saying, hey guys, this is what we think are the best practices that you should be implementing as fiduciaries of retirement plans in the area of cybersecurity. That's not to say that simply because it's not formal guidance, you can basically ignore it. We always want to pay attention when the Department of Labor is telling us what they think we should be doing, even if we might have a legal argument that we're not legally required to do it. And so this guidance took the form of best practices for service providers that are involved in administering retirement plans. It also included tips for plan sponsors to use when hiring service providers or continuing to monitor those service providers that are performing services for their benefit plans. And then the third area is online security tips directed at plan participants to safeguard their own accounts. So a recognition that plan participants play a role in ensuring the security of their retirement plan accounts. We're primarily talking about 401k accounts because those are the accounts that folks have access to and online access through passwords, etc. So what should plan fiduciaries be doing? They should be familiarizing themselves with this guidance. So if you haven't already done that, set that as the first thing you should do first of next year, because I'm sure you have plenty of other things to do between now and year end. Evaluate whether your service providers practices are consistent with this best practice. Also check your contractual provisions to ensure that your service providers are bound to have and follow good practices, best practices in this area. And finally, you should you should also be incorporating these best practice tips in any kind of RFPs that you might be issuing if and to the extent you're searching for new service providers. Another thing you should be doing is communicating these online best practices to plan participants. So consider an educational campaign, reminders to participants in the benefit plans about things like not sharing their passwords, etc. Include the model language that the Department of Labor has provided us in summary plan descriptions that are issued for the benefit plans. Consider whether you should be requiring multi-factor authentication for account access. Many record keepers do have this available. Some of them are automatically requiring this. Some of them are requiring it if you actually tell them you want them to require it. Some of them are requiring multi-factor authentication only for sort of high-risk transactions. So when withdrawals are happening from the plan, this multi-factor authentication would be required, but for other lower risk items, it's not. Investigate whether or not your service provider might offer some type of guarantee or insurance protection in the event a plan participant's account is impacted by unauthorized activity. And then, consider to what extent you need to look at other benefit plans and other service providers and compare what they're doing around cybersecurity with this guidance. I will say that we know that the DOL has already, commenced reviews of these practices among plan sponsors. Plan sponsors have received questionnaires from the Department of Labor asking them about cybersecurity practices and policies that they've implemented, steps they've taken. We also know that service providers have received such information requests and subpoenas for information. So this is something the Department of Labor is taking very seriously and probably should be something that you focus on if you have not already. The next item I wanted to highlight is an update to the EPCRS refers to the IRS's self-correction, correction program, I should say, for correcting errors within retirement plans. And this is a big piece of guidance. It covers a lot of different types of errors. It allows self-correction in certain cases. It also provides a a more formal program that you can apply to correct maybe more significant errors. And this guidance changes every 2 to 3 years. And earlier this year, the IRS issued an updated version of this guidance. Not going to go into too much detail. I think the main message here is that this guidance does change and did change earlier this year. So if you have errors that pop up in your 401k plan or even your DB plan, if you have one, don't just assume that the way you corrected it before is the way you need to correct it now, or that maybe if something wasn't eligible for correction before, it's still no longer eligible. I would encourage you to consult with legal counsel if errors pop up and make sure that you're carefully evaluating exactly what your options are under this sort of new version of EPCRS. The other topic that should be top of mind is missing participants. This is not really a brand new issue, although we did get some guidance from the Department of Labor on this issue back in January. Again, I use the word guidance, but again, it's not in the form of formal regulatory guidance. It's in the form of best practices that they posted to their website and told you they think you should be following. And basically, the Department of Labor and also the IRS, I think, is beginning to really kind of focus on this issue too, is very concerned about the growing number of people within retirement plans. It started with defined benefit pension plans, but I think it's quickly also begun to focus on 401k plans who, go missing. Whether that means they're being sent required notifications and the mail is being returned saying, there's no one at this address with this name, or maybe people, within plans who are approaching the date by which distribution should begin to them. Maybe it's the minimum required distribution date and they haven't begun. Or beneficiaries in the plan that should be getting a distribution of the amount that's in the plan, and that hasn't begun. Usually it hasn't begun because the people can't be found. So the Department of Labor has flagged a number of items that they think are red flags, that indicate you have a missing participant problem. And I will say, you're almost always going to have missing participants. This is a problem that's never going to probably go away completely. But what the Department of Labor wants to see is that you have a very low number of these situations and that you are taking reasonable measures to try to locate people. So if you have more than a small number of missing or non-responsive participants, if you have more than a small number of people that are beyond the time that they should have received their benefit from the plan, if you have inaccurate information, so 999999999 as the Social Security number for somebody, or for 100 people in the plan, that's a red flag. You've got faulty data, you have faulty data, you should be showing that you're taking steps to figure out what the right data is. An absence of written policies and procedures for handling return mail is going to be a red flag. The absence of sound policies and procedures for handling uncashed checks. Uncashed checks is a form of the missing participant issue. These are all things that if you were not already previously monitoring, you should take a look at and you should add to your list of things that will need to be monitored on a going forward basis. Again, this isn't something where you're like, yep, we address missing participants, we're done. That's almost never going to be the situation. So I created on this slide a list of sort of best practices and suggestions for where to start and how to prioritize this, especially if you really haven't focused on it. The first thing to do is get a list from your service providers of who they believe the missing participants are and the uncashed checks. Start with the active people first. You'll be surprised how many people on that list are actually actively employed and where they are, but somehow there's been a disconnect between getting that information from you to the record keeper. Start with, higher balance people first. Start with people who are beyond the date that they should have commenced their benefits. So hopefully these will be helpful steps in getting you started on this process. Identifying beneficiaries. This is not anything new. There's been no new guidance. It's the same old rules, but for some reason I'm encountering an increasing number of sort of questions and misunderstandings about how to determine who the appropriate beneficiary is, let's say under a 401k plan. I'm going to stay focused on 401k. And the general rule, which again is not a new rule, is if the participant was married at the time of their death, the surviving spouse is automatically deemed to be the beneficiary unless that spouse consented to a different beneficiary. Doesn't matter, you know, if the participant tried to fill out a form and specify her son, if she's married, you know, the husband is the beneficiary unless the spouse has consented to an alternative beneficiary designation. And another thing to keep in mind is a properly completed beneficiary designation form for the 401k plan will be the controlling document, not the beneficiary designation form filled out for the life insurance benefit. That's a different form, that's a different plan, there's different rules that govern. I was surprised to learn that one client was doing that. They said, well, if they don't have a beneficiary designation on file with 401k, then we look to their life insurance beneficiary designation form. No, you don't do that. If there's no form, the plan document controls. And the plan document can surprise you in terms of what it says about who the beneficiary is in the event someone dies who wasn't married at the time of their death and didn't have a beneficiary designation. A lot of plans are really simple and they say it goes to the estate of the participant. But other plans say, no, first, if that's the case, surviving children. If no surviving children, surviving parents. If no surviving parents, surviving siblings. If no surviving siblings, you know, estate. So you have to follow the terms of the plan you know, really need to understand what those rules are. There can be a lot of complicated issues that come up, and I would counsel you to consult with legal counsel anytime any of these issues come up. Well, except for the first one, I get clients calling me saying, well, they were estranged. They were in the process of getting divorced. You know, can we just sort of act like they were divorced or, you know, ignore this estranged spouse or estranged parent? No, you cannot. There's no basis to do that. And if you do that, then you're running the risk that that estranged person will sort of one day show up on your doorstep and say, hey, you know, I heard this person passed away and I was entitled to the benefit. Where's my money? You say, well, we paid it to, you know, the mom, and because we heard the dad, you know, was estranged. Okay. The beneficiary can't be located. You can't determine the beneficiaries. Do they have surviving children? Do they have surviving parents? I always say, let's look at the obituary, if there is an obituary. It's not formal official guidance of these details, but it's certainly a clue that might lead us in a direction to make this determination. Sometimes estates are never opened. I say, too bad, you have to open an estate. We're not paying 50 grand out, you know, to anybody other than the estate. Beneficiary is a minor, in which case you can't pay to the beneficiary. You could pay to a court-appointed guardian. Otherwise, you have to wait till they reach the age of majority. Power of attorneys, these are becoming more and more prevalent, and I think my word of advice with respect to power of attorneys is to proceed with caution. I think there's a solid basis for plans to only recognize the authority of an attorney, in fact, with respect to an ERISA governed plan, when it's been demonstrated, you know, in very limited circumstances. And I would suggest those are situations in which it's been demonstrated the participant is just incapable of taking the action him or herself with respect to the plan benefit. You know, there's the logic behind this is ERISA preempts state law. And the risk is that, you know, the participant could come back and say, what do you mean you paid the money to my son? And we say, well, he presented a power of attorney. And then the participant says, yeah, but I revoked that power of attorney years ago because, you know, my son was taking my money and absconding. So be very cautious with power of attorneys and attorneys, in fact. The final thing is just a slide reminding you of some various amendment deadlines for qualified plans. I think the most important deadline this year is the deadline for amending 401k plans for the hardship withdrawal changes is the end of this year. So these were changes that were brought into law back in 2018, could have affected plans as early as 2019, but we're at the stage now where we have to adopt formal amendments that reflect those changes that we've already sort of operationally implemented. Next year will be the year to amend plans to reflect changes to 401k plans that occurred in connection with CARES Act. Those were primarily limited to the 2020 year, but we have until next year to amend the plan to sort of say what we did. And next year is also the deadline for amending for Secure Act related changes. One of those changes, for example, was the change in the minimum required distribution age from 70 and a half to age 72. So I am going to, because my time is up, turn this over to my colleague to talk about a few health and welfare topics. Thank you.
Thanks, Laura. I am going to start off by talking about something very optimistic, which is the end of the pandemic. And I will say that I know nothing more than any of you all do about when the pandemic is going to end. I just know it's got to end at some point. And so when it does end, there are things we need to think about from a benefits perspective as far as changes we've made to our plan. Do we need to unmake those changes? Can we keep things the same? What do we need to be thinking about from a documentation perspective? So that's the first part of today's focus. And then I'm going to spend a little bit of time talking about a new requirement that comes into play 1/1/22, which is surprise billing and reporting requirements under the Consolidated Appropriations Act. This is something that we are still trying to get our arms wrapped around, and your vendor partners are still trying to get their arms wrapped around. And knowing that the audience here is not necessarily in the weeds of benefits, we're going to give you sort of a high-level sense of what is required and what you might need to be thinking about or making sure your benefits folks are thinking of. For those folks who are in the weeds on benefits, who are listening or here today, just know this is going to be a more high-level presentation than what you would typically see. So let's start by clarifying, what do we mean when we talk about the end of the pandemic? For benefits purposes, we have two sort of different emergencies to think about. The first emergency is the public health emergency. So this is declared by the Department of Health and Human Services. It was first declared on January 30th, where Health and Human Services determined that the public health emergency began January 27th of 2020. Now, it runs for 90 days, and it can be renewed over and over and over again. It was most recently renewed October 15th of 2021, which means it's going to expire in January unless it is renewed again. I do not have any sense that it won't be renewed again, but as vaccinations become more prevalent, maybe there's a light at the end of the tunnel and we'll see some end of this period, but keep your eyes open for that. That's the public health emergency, or it may be referred to as the PHE in these slides. Then we have the national emergency. The national emergency has been declared by the president. That was declared March 13th, 2020, and it was determined that the emergency began March 1 of 2020. This emergency period generally runs for about a year, and it can be renewed. So it was most recently renewed February of 2021. Again, don't have any sense as to whether it will be renewed. Probably will. It can also, both of these emergencies can be terminated early. So that's important to know too. So the requirements that we're dealing with today are geared toward either the public health emergency or the national emergency, or both. So most group health plans were required to make a number of changes during the pandemic. This slide shows you the changes that were required to have been made. And those changes generally can continue after the pandemic if you want them to. So I just want to be sure you don't set this and forget it. You actually can go back to pre-COVID terms if you want to, or you can continue as is, subject to this little asterisk here. So the requirement for group health plans was to add coverage without cost sharing. So employee pays no co-insurance, no deductible for COVID-19 diagnostic testing and the related office visit. And I know Beth earlier today talked about the fact that this is diagnostic testing. This is to determine whether you have, you think you have COVID-19. This is to confirm, not fit for work testing that you're doing solely to prove that you can come to work because you're not vaccinated. That's what's required to be covered under the plan.
At the end of the pandemic, after the public health emergency, the plan may again impose cost sharing on COVID-19 diagnostic testing and the related office visit. We're also required to pay a certain amount to providers for the COVID-19 test. After the end of the public health emergency, we can charge whatever the plan feels is appropriate. And then during the public health emergency, we have to cover COVID-19 vaccines at 100% in or out of network. After the end of the public health emergency, we still have to cover in-network vaccines at 100%. That falls under the preventive care rules of the Affordable Care Act. But we don't have to cover it at 100% out of network. Now, I mentioned a little asterisk to the fact that you could continue to do this. These are medical services that have cost sharing requirements. And whenever you think about waiving cost sharing requirements for medical services, you have to think about what impact that might have on your mental health parity testing. It is entirely possible that by waiving these copays or coinsurance or deductibles, we are then requiring the plan to waive cost sharing for certain mental health services. So during the public health emergency, we don't have to worry about that. The agencies have said they're not going to assert a mental health violation. But if you would continue to waive this after the end of the public health emergency, you've got to think about your quantitative treatment limitation analysis under the mental health parity rules. Then we had some optional changes. And so these were changes that group health plans were permitted to make during the pandemic. And these cannot apply after the pandemic. This is special relief that the IRS and DOL or legislation gave us to deal with the pandemic. Once the pandemic is over, it is no longer permitted. So first is you can provide first dollar coverage for telehealth services under a high deductible health plan. You know, clearly, while we were in lockdown, there was a lot more use of telehealth services, and we were trying to encourage people not to go to the hospital, unless they really needed to. Don't go out and see your doctor and infect a whole bunch of people if you don't really have to. So the agencies gave us this ability to say, you can pay first dollar coverage for telehealth services without destroying someone's ability to contribute to an HSA. Now, until future guidance is issued, we can continue to provide telehealth services for COVID-19 related issues. But beginning 1/1/22, if you've got a person in a high deductible health plan, they have to be charged cost sharing for any telehealth services that are not preventive or for COVID purposes. And we can offer a telehealth plan only to employees not enrolled in a medical plan. This is a special exception to certain ACA rules that say if you've got a group health plan, you have to comply with a whole bunch of design requirements. They're sort of carving telehealth out of this only during the pandemic. But beginning with the first plan year after the public health emergency, that's not going to apply anymore. So if you've got a telehealth only plan that's being offered to people who are not enrolled in your medical plan, you'll need to do an analysis as to whether that is a group health plan that's subject to the Affordable Care Act, or whether it's an accepted benefit that you can continue to offer without all the bells and whistles of an Affordable Care Act plan. Additional relief that we got during the pandemic: unlimited carryover of flexible spending account funds, the ability to contribute more to a dependent care FSA, the ability to provide COVID-19 diagnostic testing under an EAP without losing accepted benefit status. This one I want to pause on for just a minute because of the ETS, because of the things you've heard about earlier today with COVID vaccines and testing programs. And I know Beth went into detail about, well, if you're paying for testing, does that create a group health plan? This doesn't answer that question, but the agencies have said, if you decide to offer a testing program as an ERISA plan, you can do so without adding all the ACA bells and whistles. After the end of both the public health emergency and the national emergency, that's not going to be the case anymore. So you would have to take a look at that program and see, does this in fact provide significant benefits in the nature of medical care, and figure out, if we need to do something different with the testing only program. And during the pandemic, we have some relief from providing notices. So we get to take good faith efforts to get notices out when and how we can. Beginning 60 days after the end of the national emergency, our deadlines for responding to document requests and getting notices out will apply as they did pre-COVID. Additional optional changes, which may continue. So contrasting the past two slides, these changes may continue to occur after the pandemic. We can provide COVID-19 vaccines under an EAP without losing accepted benefit status. So contrast that to the testing program I just talked about. Even after the end of the emergencies, we can pay for vaccines as an ERISA plan without bringing in the ACA requirements. And our flexible spending accounts and health savings accounts can reimburse over-the-counter drugs, menstrual care products, and COVID-19 personal protective equipment. That's something that doesn't appear to be impacted by the end of the emergency. It was sort of a general rule that said, we're going to consider these things medical care, and your flexible spending account can reimburse medical care, so these are things you can do. And oh, that's my computer's flipping for a second here. So thinking about the end of the pandemic and notifying people about changes, once you've decided what changes you're going to make, then we need to think about amending the plan, notifying participants. Generally, amendments have to be effective prospectively, which means you would need to amend the plan ahead of time to make the change. And from a practical perspective, you're going to know what the change you're going to make is before the change is made, so you can do that amendment. But we don't necessarily know when the end of the pandemic is going to occur. It may be that the agencies announce, we're stopping this relief today, or the president decides, I'm ending the national emergency today. So it's entirely possible that we won't know until the day of when our emergency ends. There's a special rule under the Affordable Care Act that says if you made a change that impacts a particular notice that has to be given to participants, this summary of benefits and coverage, you have to give folks notice 60 days before that change takes effect. If we don't know when the pandemic's going to end, we don't know how to give notice 60 days before the end of the pandemic. So we've got this special rule which says that if you have told people that you're planning to make this change as a result of COVID relief, and it's only going to be effective during this general period, then you can go back to normal at the end of that general period without providing advance notice. And then grandfathered plans, if you still have a plan that's grandfathered under the Affordable Care Act, going back to normal is not a change that would cause you to lose grandfathered status. Another aspect of COVID relief is deadline extensions. So we were told back in May of 2020 that the outbreak period, which I'll explain in a minute, has to be disregarded when we determine extensions for HIPAA special enrollment deadlines, deadlines for electing COBRA, paying for COBRA, providing COBRA notices, filing a claim under an ERISA plan, requesting an appeal under an ERISA plan, requesting an external review under a medical plan, and perfecting an external review. So deadlines for these actions have been extended during the outbreak period. And you can see some of these extensions really only apply to the medical plan, but some are going to apply to all ERISA plans, including retirement plans. So what do we mean exactly? So the outbreak period is slightly different from any of the emergencies we just talked about. It's actually the national emergency plus 60 days. So it started March 1 of 2020 and is going to extend for 60 days after the end of the national emergency. It is possible that the national emergency ends in different parts of the country at different times, or that the outbreak period is announced before the end of the national emergency. This is what we know right now. Now, in May of 2020, the agencies told us we can't take into account the outbreak period when we're applying deadlines. I think at that time, they clearly didn't expect how long the outbreak period was going to last, because they don't have authority to require us to extend deadlines for more than a year. So in February of 2021, when they're coming up on the end of the 1 year mark, they come out with more guidance, which says, we recognize that we don't have authority to require you to extend deadlines for more than a year, so we are going to say that you don't have to extend for more than a year. And then they issued some additional guidance in October of this year. So let's look at how this works. So let's assume, let's hope, the national emergency ends on January 30th, 2022, and the outbreak period ends March 31 of 2022. Back in 2020, when we got this first wave of guidance, we knew that the outbreak period needed to be disregarded in determining a COBRA election deadline. Now we know that the outbreak period, but not more than a year, has to be disregarded. If we assume that a COBRA qualified beneficiary's 60-day COBRA election period began 10 days before the outbreak period, employers have a couple of different options on how to apply these extensions. They can do just what is required, which is to say, your deadline, your clock for electing COBRA started February 20th. And then when the outbreak period hit, the clock stopped. At the end of the outbreak period, or at the end of the 1-year mark, now that we know that, we're going to start our clock again, and you get 50 more days to make your election. Or some employers took what's called the full approach, which is, we know that you already had 10 days out of your 60. We don't care. We're forgetting about that. At the end of the outbreak period or your 1-year mark, we're going to give you the full 60 days again. Now, there was a question about initial COBRA payments because the deadline for COBRA payments is dependent upon when somebody actually makes an election. So pre-COVID, if somebody gets a COBRA notice, the date that the COBRA notice is provided starts the 60-day clock running for somebody to elect COBRA. Once they elect COBRA, there's a 45-day clock that runs for making the first COBRA payment. Now, both the election deadline and the payment deadline are subject to these extension rules. So, what does that mean? Does that mean that a participant, has a year and 60 days to make their election, and then a year and 45 days to pay for the coverage? The IRS issued some clarifying guidance in October that said, no, those extensions are going to run concurrently. So let's look at an example. Let's say an employee's COBRA election notice, same example, dated February 20th, 2020. So absent the outbreak period, they would have to make their election by April 20 of 2020, and then they'd have 45 days after the date of their election to make their first payment. In May of 2020, we were told, ignore the outbreak period. And as a good employer, good plan fiduciary, we reached out to our participants and we said, the outbreak period is not going to be considered as part of your deadline extensions. Then in February of 2021, we learned that the election deadline need not be extended beyond April 20th of 2021. That's the 1-year mark from the original deadline. Did we tell our participants that the deadline is now being shortened? Some employers did, some employers didn't. Then in October of 2021, we got that guidance about the periods running concurrently. So did we tell our participants when their payment deadline, now is going to be interpreted to be due? How does the plan respond if this employee elects COBRA on May 1, 2021, right? They were told they'd have until after the end of the outbreak period to make their COBRA election. If they weren't told that their deadline now has been, accelerated to April, maybe we don't have the right to deny them COBRA coverage based on this untimely election. It's something that you're going to have to work through on a case-by-case basis, depending on the communications that were issued to your participants. Now, what if the employee elects COBRA on April 1, 2021 within their extended deadline period and makes the payment May 1, 2022? So under the first 2 waves of guidance we got, that payment would seem to be timely. But under the 3rd wave, it wouldn't be. Did we tell our participant that? If not, maybe we don't have the authority to deny them COBRA based on that. So I say all this to say, as you're thinking about the end of the pandemic, you're going to want to determine the extent to which your plan design will go back to normal, will continue with whatever relief you can. What you don't want to do is just go on autopilot, let those changes roll over when you're no longer allowed to have those changes in your plan. Very important for telehealth services, because a lot of folks waived cost sharing for telehealth services during the pandemic. Beginning 1/1/22, you can't waive cost sharing for telehealth services that are not preventive and not COVID related for anybody who's enrolled in a high deductible health plan. Otherwise, you destroy their ability to contribute to an HSA. You want to consider the extent to which communications, including any advance notice about plan changes, should be provided. You also want to confirm, how have you been applying this deadline extension guidance? And what have you communicated to participants? Should you be communicating more to participants? Should you be giving them a heads up once you know when the outbreak period is going to end or when their 1-year deadline is going to end? You want to think through what makes the most sense so that you can be fair to your participants and also comply with the law. That takes us now to surprise billing and transparency. So beginning with the first plan year that starts on or after 1/1/22, we have new rules that protect participants against surprise medical bills. These are going to apply to emergency out-of-network services. They're going to apply to out-of-network services provided at an in-network facility unless certain notice and consent requirements are met. And they're going to apply to out-of-network air ambulance services. So for all of those types of services, we have 3 new protections. We have a requirement on the amount that can be charged to the participant. We have a process for determining the payment that's due to the provider. And we have an absolute prohibition on the provider's ability to balance bill the participant. And for those of you who are not familiar, balance billing means the plan has paid what the plan is required to pay. The participant has paid their cost sharing amount, but the provider thinks they're still owed more. So they go after the participant for the amount that neither the plan nor the participant has already paid. That will be prohibited under these circumstances. So because there's a change to the amount the participant is going to pay, the plan needs to know this new concept called a qualifying payment amount, which generally is going to be the median of the in-network rates that are charged for that service. So there's some work that the plan administrator or insurance company is going to have to do to determine that amount. Once that amount is known, you will know how much you can charge the participant. So for example, if co-insurance for a particular service is 20%, the question is 20% of what? We need to know what the QPA is in order to apply that 20%. Then we have a process for determining how much the provider is billed. And so the way this process works is that first, the out-of-network provider is going to submit a bill to the plan. The plan is going to determine how much should be paid based on the terms of the plan. And within 30 days, they're either going to send payment to the provider or they're going to tell the provider that no payment is owed. The provider then, if they don't like the amount that's been paid by the plan, can go back to the plan and open a negotiation period and say, I think you owe me more, let's talk. If after 30 days, the plan and the provider don't come to an agreement, then either party, but really it would be the provider, can go to an independent dispute resolution procedure or an IDR procedure. This essentially is baseball arbitration. So in this situation, each party is going to submit to the IDR entity the amount that they believe is the right payment to the provider. The plan says, this is what I think we owe the provider and why. The provider is going to say, this is what I think the plan owes me and why. Then the arbitrator is going to take both of those into account. There are some things they have to consider as part of this decision and some things that they can't consider as part of this decision. And then they're going to pick one or the other. There's no negotiation here. There's no compromise. There's no splitting the middle. They pick one or the other. Whoever's amount gets picked, that is the amount that's owed to the provider, and there's no further dispute. The winner, obviously gets their payment amount. The loser has to pay the cost of the arbitration, but both parties have to pay a fee to the government for the benefit of using this arbitration procedure. So your third-party administrator, if you've got a self-funded plan, or your insurance company, if you've got a fully insured plan, really should be on top of all those requirements. They should be administering the plan as required by the law. There's not much for an employer to do in that process other than make sure your administrator or insurer is complying with the law. And you may want to have a discussion, especially if you've got a self-funded plan, with your TPA about when they go into this arbitration, what amount are they going to be proposing? Because if they propose an amount that's too low, chances are, the arbitrator may choose the provider's amount, and we may be out more money than we otherwise would have if we had proposed a slightly higher amount. So there's going to be some strategy that goes into negotiations with the provider and choosing the amount to be submitted to the arbitrator. But something that the employer absolutely has to do is post this surprise billing notice. So there's a notice that must be made publicly available and posted on a public website of the plan no later than the first day of the first plan year that begins on or after 1/1/22. So for those of you with calendar year plans, this needs to be posted by 1/1/22. Now, what does it mean to be made publicly available? What does it mean to be posted on a public website of the plan? Chances are your health plan does not have a public website. In most cases, employers set up intranet sites where participants have to log in order to see information about the plan. Informal comments from the Department of Labor suggest that intranet site posting does not satisfy the public disclosure requirement. However, informal comments by the DOL also confirm that you don't have to create a public website just for this. So there's got to be some other way that you can make something publicly available and post it on a public website of the plan. Maybe it's talking with your insurance company or your administrator to see if there's a way to post on their site. They may have their own notice, which you can just point people to. This is not something where you need to give it out with open enrollment materials every year. This is not something that you need to give to new hires upon hire, but it's something that you have to figure out how to make publicly available and post on a public website of the plan. The IRS and DOL have said they are not intending to provide us any guidance on how to do this before the deadline. So at this point, it's coming up with a reasonable good faith interpretation of how to do this. Now, it does also have to be provided with each explanation of benefits that goes out with a claim that's subject to the surprise billing requirements. That's something your insurer administrator should be doing for you. Your focus is how do we post this on a public website of the plan and make it publicly available. In addition to administering surprise billing claims and providing the surprise billing notice, there are a number of requirements under the Consolidated Appropriations Act and under regulations that were issued prior to the Consolidated Appropriations Act that require a group health plan to provide certain information, to treat claims in a certain way and to tell people about it. In addition, there are some sort of nuancy requirements that go along with this. So this slide and the next slide identify some of those requirements, which the IRS and DOL addressed in guidance earlier this year. Now, some of these requirements, as you can tell from the original effective date, were going to be effective December 27th of 2021. Others were going to be effective for the first plan year that starts on or after January 1, 2022, and some had even further effective dates. The IRS and DOL gave us a little heads up on what they expect you to do pending guidance and gave us some delays so that they could get guidance out before we had to comply with the requirement. First item here is something that you should be paying attention to, which is the prohibition on gag clauses. And this will go into effect, December 27th of this year. Departments are not going to issue guidance on how to do this. So we have to make a reasonable good faith attempt. What is a gag clause? A gag clause simply is a provision in a contract that you have with your TPA or your network provider that prevents you from disclosing the things that you need to disclose in order to comply with the transparency requirements. So a little more nuanced than that, but that's the general concept that nothing can prevent us from complying with the law. So you'll want to check your contracts that you're entering into on or after this date to make sure that you're not entering into a contract that violates this clause. Now, there will be a requirement to attest to compliance in the future. We are expecting guidance before you have to submit that type of attestation. Then we're going to have some prescription drug reporting. So we did get some proposed regulations on this, and the IRS and Department of Labor have told us originally we were supposed to report on 2020 data by December 27th of 2021, and then report on 2021 by June of 2022, and then annually in June thereafter. They are delaying the date for these first two reports until December of 2022. That doesn't mean they're waiving the obligation. You're still going to have to report on 2020 and 2021. So it's something to think about and make sure you're prepared for 2022. Other compliance obligations in here, again, not going to go into the weeds on many of these, but just know, I think this guidance that we got from the IRS and the DOL gives us and our vendor partners the green light to go ahead for things where we know we're not going to get guidance, right? The vendor should be already moving toward compliance in the way that makes the most sense for them and for you, and gave us a little bit of breathing room for certain of these requirements to say, okay, we don't have to prioritize this. We don't have to worry about this. We can wait for guidance to figure out how this is going to shake out. So issues to consider when you're thinking about Consolidated Appropriations Act compliance. Because of the change in surprise billing, because you're going to change the amount that a participant is required to pay, because you're going to change the way the plan determines how much is payable to a provider, your plan probably has to be amended. And most likely the way this works is by updating the medical SPD. So your medical SPD will define, what coinsurance is, what a co-payment is, how to determine the amount that the participant is required to pay. It usually also has a definition of recognized amount or allowed amount, or usual and customary, something like that, that identifies how the plan will determine the amount that's going to be paid to a provider. Now, with network providers, it's not a big deal because the TPA or the insurance company and the provider have already come to an agreement on what amount should be paid. This is really focused on out-of-network providers, and for this purpose is really only focused on out-of-network providers who are providing emergency services or providing services at an in-network facility or air ambulance. So we're going to have to amend the plan, update the SPD to reflect these changes in the way these claims are processed. And then you're going to want to think about, to what extent do we want to have any control over the amount that's negotiated with the provider or the way that the IDR process is run? Most employers are probably going to say, have at it, I don't want to be involved. But if you've got a self-funded plan, this is your money, right? So you may want to have a discussion with your third-party administrator about what is the process that they're going to use to do this. Now, I will say, prior to the Consolidated Appropriations Act, a lot of third-party administrators were already engaging in negotiations with out-of-network providers to prevent surprise bills. So this may not be a new process. It may just be formalized in a different way. Obviously, arbitration is the new process, but the negotiation process, your third-party administrator may already have down. And then you want to confirm the extent to which your provider, your vendor, is going to satisfy the Consolidated Appropriations Act requirements on your behalf. Now, if they are administering your plan, and if they have agreed to administer your plan in compliance with the law, they probably already are, contractually obligated to administer the surprise billing claims in the right way. But there's a number of other requirements, as I just mentioned, that they don't have to do while administering your plan. Prescription drug reporting. There's going to be some reporting on air ambulance services. There's going to need to be a tool available to participants to allow them to understand, get an advanced estimate of the cost that may apply to their services. There's going to be machine readable files that have to be posted somewhere that identify certain information about the plan. These types of things are extra services that are not currently required under the terms of your contract, most likely. And so if the vendor is really the best person to do those things because they have all the data, they can crunch the numbers, they can provide the reporting. Many of the TPAs have already said, yes, we're going to do this, but you want to check with your TPA to see, are there any services that they're not going to provide? Because if so, you need to find somebody else to do it, or you need to figure out how to do it yourself. We have not seen many contract amendments come through from TPAs yet, and we would love to, right? We, especially for self-funded plans with a services agreement with a third-party administrator, I want to see that third-party administrator say, I'm going to do X, Y, and Z for you. I'm going to do it in compliance with the law, and I'm going to indemnify you for any losses you incur if we don't do that. We have not been successful in getting many of these done yet. All the vendors are saying, we're still trying to figure out, we're not ready for contract amendments yet. And so come 1/1/22, you may be stuck. Now, that being said, probably 1/1/22, the only thing that needs to happen is that a out-of-network claim gets administered in the right way. And so, we may have a little wiggle room before the real risk kicks in. So I wouldn't say to you, rush out right now and make sure you have a contract amendment in place by 12/31. I've been saying that all along, and I think at this point that's probably unrealistic. But as soon as we can get these amendments in place, we want to get these amendments in place to protect the plans. And that takes us to the end of our presentation. I don't know if we have any questions from the live studio audience. If so, I'm happy to take them. If not, then, there's our CLE tracking code. So if you're requesting CLE for this presentation, the code is T as in Thompson, H as in Hine, Thompson Hine, TH, 128D, D as in David. All right. With that, I think I'll go ahead and turn it over to Eric.
Thank you.
All right, thank you, Kim and Laura. That was very helpful. So Anthony McNamara and I are going to talk a little today about reductions in force and considerations and best practices. We are aware, as you dig into this, we are aware that right now there's more of a hiring shortage or a shortage of applicants, but oftentimes in our practice that is quickly followed by the need then to downsize or go through the process. And we haven't talked about this in a little while, and we're worried some of these things may roll through, so we thought we'd give you a little update. Here are a couple of things we're going to talk about: alternatives to reductions in force, best practices in conducting a reduction in force, and then defending the RIF decision and rollout in court as needed. So the first thing is, what is a reduction in force? A lot of people use the term RIF sort of interchangeably with a furlough or a layoff, and they don't really all mean exactly the same thing. So I just want to talk a little about that. The first issue is reduction in force is the only one that really has sort of a legal recognized definition. That's the one that we're really focused on because that's the one that comes up in litigation the most. And that really involves the permanent elimination of one or more positions within a company's workforce for a legitimate business reason. Usually, for example, like reduced demand or improved efficiency, shortage of funds, things like that, that would cause us to need to reduce the workforce. And the general idea is a reduction in force happens when we have no intention of replacing that position. It should never be the situation where you're doing a reduction in force so that you can hire someone else in to take that job. That's not a reduction in force. That's firing one person and replacing them with somebody else. So that's the general idea of what a RIF is. A furlough and a layoff are a little less clear. I always sometimes refer to the Oxford definition. And some people will say that a furlough and layoff are different, but Oxford says that a furlough is ironically to layoff workers, so it actually uses the same word in there, especially if it's temporarily. Whereas a layoff is a discharge, especially temporary, of a worker or workers. So really those two terms, which some companies will use to mean different things, are really effectively the same and usually have some kind of temporary nature to them, which is oftentimes how it's different than a reduction in force. One thing I would note, so when we're talking about reduction in force today, the fact that you're doing a temporary layoff or a temporary furlough, that does not necessarily eliminate the legal risk of doing those things. It's just not necessarily the same standards from legal review as reduction in force. And if you do meet that standard of reduction in force, it will substantially affect your legal burdens, which Anthony will talk about in a little bit. All right, so here are the common laws that we see litigated in reduction in force cases. The most common is probably the Age Discrimination and Employment Act. There's also the Workers Adjustment Retraining Notification Act. There are some, a lot of other litigation on Title VII issues or ADA issues, and also some state Warren Act issues, the most common things. The first thing we ask when the first thing any plaintiff's employment lawyer will ask, or that we will ask in the consulting process, is, was a RIF necessary? In fact, that's really even part of the legal review process, is what was the reasoning for your RIF? And oftentimes the number one reason is the motivation to reduce expenses. Our sort of best practice tip here, and the thing we would strongly advise, is to make sure as you're going through that process that you're asking the question in advance. Why are we doing this reduction in force? And then document that before you go through any of the other procedures, before you're doing a selection process, before you're implementing the selection process. In advance, there should be some kind of communication about the motivation for the RIF and what the goals are. And then I would encourage you, whether in-house lawyer or HR, to make sure you're asking difficult questions about whether that motivation, that goal, has any legitimacy to it or has any holes in it that a plaintiff's attorney may poke into. And part of the reason here is sometimes when we use things like cost as the general motivator, in fact, the workforce reduction itself has unanticipated costs or maybe even anticipated costs that we haven't accounted for. And those things include things like severance payments, legal fees, the workforce attrition issue, hiring costs down the road, effects on employee morale. Another one of the things that we see a fair bit is when you do reduction in force, sometimes another person is asked to pick up more of a burden, more of a workload, for the people that got let go, and they end up receiving sometimes substantial increases in pay as a result of that, which seems sometimes inconsistent with the motivation of reducing the workforce to reduce costs. Sometimes there are other options instead of a permanent reduction in force. Things you can imagine, things like the furloughs, hiring freezes, wage freezes, reduction or elimination of bonuses, changing the fringe benefits or reduced work hours. To be frank, some employers believe are the panacea. They will do them every time. And other employers think they cause more morale issues than if you simply do a reduction of force. And the only thing I can tell you for sure is that every organization has a very strong opinion about it and believes they are 100% correct, and that almost every organization does it differently. But there are certainly things to at least consider as you go through the process. All right, the best practices to consider while you're going through a RIF. Here are the things we're going to talk about over the next few minutes. The first is determining the basis for the RIF. We talked a little about that earlier, but I'll go through a little more. Determine the type of reduction of force you're going to do. Develop a uniform selection criteria. Conduct a layoff analysis, a legal analysis, including statistical analysis. Provide advance notice of the reduction of force. Severance and ERISA considerations that may come into play. Determine whether to seek a release agreement from the affected employees and or to offer them severance, and effectively communicate the termination decision. All right. So as we said before, the first thing to do is determine the basis for your reduction of force. In the burden shifting analysis of litigation, the burden is absolutely on the employer to articulate a legitimate non-discriminatory basis for the RIF. The best time to come up with that legal defense, the litigation strategy, is to do that at the very beginning of your RIF process. What is the motivation? Sometimes it happens that employers or managers see a reduction in force as a way to accomplish other goals that don't really fit into the classic reduction in force process. They may say things like, oh, we just want to eliminate that position. And that may or may not actually be what's happening in terms of position elimination. It could be they're eliminating that position, but simultaneously hiring people in another department to do effectively the same role. That's not a reduction in force. That's in fact just transferring work duties from one department to another. So we need to make sure that we can withstand scrutiny from a plaintiff's attorney about what that motivation is. And sometimes we find that putting things in writing, putting things under a little bit of scrutiny, will actually strengthen the case. If we're doing that early on, it allows us to bolster our case and make sure it's fully reviewed. And other times when we see people putting it in writing, they have a tendency to back off of their original plans and maybe find alternate and less legally risky plans that might even be better for the organization as a whole. And as internal HR or legal folks, it's sort of important that we have a little bit of an edge on this issue. And certainly when I'm consulting with the internal folks, I try to make sure that these rationale that have been articulated are consistent internally to other things that are going on in the business, other things that we know are being said or being done at the same time. All right. The next thing you really should do is determine what type of reduction of force you're going to go through. And there's really two main types. Those are voluntary and involuntary. Of course, sometimes you go through both processes. The voluntary separation program has a lot of benefits. The biggest one is it dramatically reduces your legal risk when you're offering a voluntary severance plan. It also can greatly reduce employee morale. And in fact, some of the employees who may be interested in leaving for whatever reason, they could be ready to move to a new job. They could be ready to exit the workforce for whatever reason. There's a lot of reasons that people decide that they want to take a voluntary exit package, separation package. That process creates much less turnover from an employee morale standpoint, or much less difficulty from an employee morale standpoint. But there are also some difficulties with a voluntary program, chiefly that you lose a great deal of control over selecting who may be going. Sometimes the people that want to leave may be your best performers. They may be people you're not interested in having leave. People that you're not interested in allowing to retire 2 or 3 years early because their experience is invaluable in the organization and you need them to go through the transition process. And some of the controls for those things, like putting in an employer decision about whether someone can go or not go, can create some animosity in the workforce that refuse to let certain people go. So those are some of the issues that we have with the voluntary ones. On the other hand, involuntary reductions in force have bonus pluses and minuses as well. Obviously, the most control over the selection process is an involuntary process, but the risk of future legal expenses becomes much greater anytime you're going through a reduction in force process. There are very few people that I've ever met who've been selected for reduction in force that think they were probably the right person to be picked. So almost everyone feels like maybe this should have been someone else. And those difficult decisions are usually what lead to litigation if you don't have some kind of other release process in place. Advantage to the involuntary process is it can be much faster from a cost savings perspective. A voluntary layoff process, you usually have to draft all the documents, circulate it to the employees. They have a while to volunteer for the process. Then they have a while to sign their release agreement. The involuntary reduction in force process can happen on a much faster basis. Really, I've seen it happen in days under certain circumstances. That might not be the ideal circumstance. You want to take your time and do that, but I've seen it happen in a very short turnaround. The uniform selection criteria. I would say of all of the things that I would recommend as far as a reduction in force, the most important thing you can do is develop a uniform selection criteria in advance, a non-discriminatory uniform selection criteria. And the reason is that program, that selection criteria, is the thing that will convince a judge or a jury that in fact you engage in this process on a non-discriminatory basis. So if you said in advance that we are going to use comparative sales revenue as the reason to pick who is going to be laid off through the entire sales department, and we're just going to lay off the bottom 10 people in that group, it's difficult to argue with that. Likewise, if you use performance rankings and we just say we're going through the entire organization and picking the people who have the lowest performance ratings, the bottom 10%, we're going to let those people go. It's difficult to argue with that in advance as long as that's selected in advance. It's very easy to argue with that if you're doing it sort of retroactively. Once you've already said, I'm going to lay off this person, this person, this person, and then you go back afterwards and say, oh, well, that's because they all fit into a particular group. So, the post hoc rationalization is much less defensible, which is why it's so important to do this early in the process. So 2 steps early, you pick your reason for the RIF, and then you pick your process for doing the reduction in force before you make those selection decisions. And that is what will help. In fact, frankly, this is the process to win summary judgment, is to have that process set in advance, to have it documented, have it communicated to the decision makers before those decisions are made. Then you have to consistently apply that. As Anthony will talk about, one of the key issues in the litigation process is once you've articulated your reason for selecting people for RIF or how you're going to do the process, is that the plaintiff then has an opportunity to show pretext. And the easiest way to show pretext on your uniform selection criteria is to show that you didn't consistently follow it. If sometimes you don't follow that process, then it looks like the process doesn't have much merit to it. And then again, document. This process should be circulated. It should be reviewed. Everyone should know this is how they're making the decisions, so that no one is going in advance making decisions, then learning about the process, and then going back and having to rationalize those decisions with their process. The next process is kind of a review of the selection process of the decisions and conducting risk analysis. There's a lot packed into this step, but once you've identified the process and made your selections, rolled those out, the next piece is that you need to review these decisions. And really, I feel like that's both an HR and a legal review process. HR really should be going through the personnel files as part of these processes. They should make sure the process was followed, there was compliance with the process, but they should also apply their common sense. If, for example, they're looking at a particular decision process in a particular selection group, and we said that we were going to go by seniority, and there was some inconsistency in how that seniority was calculated, the HR person should be able to apply, common sense. Maybe if we all know that the seniority data is incorrect in the system for some reason, maybe there were errors in the system, but the managers were following sort of a strict seniority system from what was in the IT system or the HRIS system, that is not applying common sense. We want to use the actual dates. I've seen before where performance reviews were improperly entered into the HRIS system. So somebody was actually rated a 3, but the in the actual written documents that they received, but the HRIS system said they were a 2, which was lower, and that person was selected for layoff as a result of the lower process. And in sort of this, foolish consistency model, the manager selected the person who was substantially older and actually had a higher performance review than the other person. And not surprisingly, that was ultimately challenged because that was inconsistent with our process. So applying these kind of common sense reviews and thinking about each decision as it's going on can be very valuable. The other thing we should be doing is looking at legal risk. Sometimes even if you have a very good process in place, there can still be legal risk. And one of the ways I see this come up a lot is with performance reviews. So if your methodology for selecting people for layoff is the person with the highest performance review, is the one who's not selected, you select people with the lowest performance review, the easiest, the mistake that is often made is not looking at who prepared those performance reviews, or what the ages of people are that are getting those various reviews, or the races or the genders of who's getting lower performance ratings, and evaluating when those were done. There are some organizations that want to use performance reviews as the reduction in force process, but they do them on a spotty basis. So for example, one person got a review in 2020, but the other person hasn't had a review since 2018. If the person who hasn't had a review since 2018 has a much lower review, or vice versa, if you're not actually matching up apples to apples, that can create some legal risk. Or if you have two different people in an organization, one is supervised by person A, who is a very easy grader, the other one is supervised by person B, who is a much more difficult grader. Comparing those across each other may not necessarily reduce your legal risk in the same way, especially if it happens that the person who is selected falls into the protected class, the person who's selected for reduction of force. And so even if you absolutely follow your process, absolutely document your reasoning, there can still be legal risk associated with these decisions. And as the in-house counsel, or even as the HR person or outside lawyers, you should be able to review those and make a risk assessment for each of those and make sure you know going in what kind of risk you expect from that. And part of that legal risk is reviewing the individual decisions, and then doing the review on a larger basis. So sometimes I see it on if you're doing a reduction in force in the operations department. So you would have individual decisions on the supervisor level, and you might compare just amongst the supervisors. But then you would also think about, are we doing the same types of reductions across the superintendent level or one level above the supervisors? Are there similar reductions happening there, or within different groups, process control or quality control group? Have we sort of unusually selected for layoff a particular group of people at a higher rate, or a higher department at a higher rate? And if so, why have we done that? It's not that it's wrong necessarily if we have, but we should at least have a good reason. And sometimes when you look at it from an overarching standpoint, if you in fact see that area that we've targeted for a higher layoff area has a higher concentration of people in a certain race, gender, or age demographic, we should consider that in making our decision and say, hey, look, is this actually risky from a legal process that we should maybe consider changing this, or at least acknowledging what our risk level is? So going through that process can be extremely useful. And then after we've done those individual, group, and department analysis and made sure we understand structurally why we're making the decisions we're making, there's also an additional level of analysis we should be doing, and that is the analysis from a statistical basis. The federal and state laws they prohibit direct discrimination on an individual, but they also have, when there's a facially neutral policy, adverse employment decisions that have an adverse effect on a group of folks who fit into a particular classification. And so after this generalized process is done, we strongly recommend that you do a statistical analysis. Now, there are a couple decisions to make from the statistical analysis process. The first one is whether you want that done subject to privilege. There are advantages and disadvantages to that process. If you do it subject to privilege, it's not going to be released to the other side. It's not subject to discovery if it has bad facts in it, for example. On the other hand, if it has really good facts in it, you have a more difficult time, not impossible, but more difficult time releasing that without waiving the entire privilege. And so the question becomes, should you do that subject to privilege? And that's a conversation you should have ideally prior to doing that analysis. There's also the issue of what level and what scope you do those analyses. It can be at the decisional unit level and the division level, site-wide level, or company-wide level. And the truth is, my recommendation is that you do it at all of those levels, so that you can get a real feel for how your non-discriminatory process has been applied and whether it's creating an adverse impact based on any of the protected classifications. And disparate impact cases can be a bit harder to defend in court because employers must show an overriding business justification for the decision if there is an adverse impact, and that nothing else could have been done to achieve that justification without the discriminatory impact. Once a disparate impact exists, the burden on the employer increases. So what is a disparate impact? This is not going to be your high school or college stats class. We could have a lot of fun with that, I'm sure, on statistical analysis, but I'm just going to give you kind of a little bit of discussion about how it's applied in the courtroom and a motion for summary judgment. There are really two tests that statistical experts will do. The first one is called an 80% rule, and that really establishes whether a disparate impact exists. And basically what that is that if the actual selections of employees within a protected class are within 20% of the expected number of impact in the protected class, then there is no disparate impact. That's basically a rule of thumb that the courts will follow. And just to give you an example of that, if there are 100 employees in the entire organization, 20 of those people are going to be selected for a RIF, and 30 of 100 are in a particular protected class. The even distribution of that, which is 1 in 5, would be that 6 employees are selected for reduction in force. That's what you would expect. If there are 7 people who are selected for reduction in force, that is going to be, that's 86%. So you're actually within the 6 of 7, you're within the 80% rule. You haven't violated the 80% rule. However, if you get up to 10, where 10 people are selected, you're actually at the 60% rule. You're at 60%, which means at that point, you have actually reached the point where an adverse impact has occurred. The next question, though, is that any statistical expert will use is whether that is a statistically significant adverse impact. Basically, is it correlation or causation? And the general rule that is applied is a 2 standard deviation rule. I am not going to go through examples of that for you because that gets a little deep into the weeds. But basically, a 2 standard deviation rule can give you about a 95% confidence interval that the adverse impact is likely to have occurred by chance or not in this case. So if you have a 2 standard deviation, that means it's likely to not have occurred by chance, which is enough for most courts to say the burden shifts to the employer to show these overriding business justifications that nothing else could have been done to avoid the process, which is a much higher burden. Okay, one of the last things I'm going to talk about here is communicating the decision. There is an incredible tendency, much like my tendency to walk in front of this podium, there's an incredible tendency for most people to say things that most human beings would want to say to another human being who's receiving incredibly bad news, like they're losing their job. And those things include things like, I'm sorry, this is a really difficult decision. I can understand, that this isn't what I wanted to do, or whatever it would do to feel like it's softening the blow. My recommendation to you, strong recommendation, is do not do those things. I mean, it's like saying don't be a human being. In fact, I think apparently due to some trademark or copyright rules, I was going to show a very good clip, but I'm not permitted to according to our copyright lawyers. If you've ever seen the movie Moneyball, there's a clip where they try to explain to Jonah Hill how he should be firing baseball players. And Jonah Hill starts with, well, and he's like, the basic explanation is, would you rather be shot, if you're going to be killed, or you want to be shot 1 in the head or 5, and slowly bleed out? And Jonah Hill says, those are my only options because those are difficult. But the answer is, it is much more cruel to go through this slow build-up process where you're sort of bearing the lead. Hey, thank you so much for coming in. Your service is really valuable to us. We've appreciated everything you've done. And you do this long 5-minute build-up to make the person feel good, only to then take their knees out and say, but we're going to have to let you go. Much better to go straight to the point. Say, thanks for coming in. The company has decided to X, or I have decided to make these decisions, or we have decided, or in my preference is Anthony has decided to make these. the reality is better to own that decision. If the decision maker can be the one who's giving the notice, my strong preference is I have decided. It's important to own that decision, not to try to shift blame onto Anthony or the company or someone else. It's either I or we, because the person giving that statement needs to own it. And in fact, generally from a communication standpoint, if you can't get that person there, they should be on speakerphone, they should be on video call, especially in this day and age. They should be on Teams or something like that if they can't be there in person. Even if there's another person physically present in the room, which should also happen as part of those meetings. I would also encourage you to always have 2 people in that room. It's useful just to make sure you have witnesses and what was said, what isn't said. I strongly encourage you to script this process, going in to have very specific statements that are made and not made. That way, when you are cross-examined by the plaintiff's attorney about what was said, you can say, I had this exact script, and this is what I said. I didn't say anything else. Those are recommended statements. But make it short, sweet, and have a letter that you give them concurrent with that process. Company's made this decision. Your employment will end on this date, as part of a reduction in force that the company is doing. Here's a letter that communicates that. In addition, this letter will explain things like your health benefits, your 401k issues, your COBRA election process, any outplacement services that will go on should all be included in there, or at least be easily referenceable. If there is a severance agreement, you may want to give the person the severance agreement at that time. That sometimes is the best way to soften the blow after you've given them bad news. Provide any information you have about EAPs, and then offer availability to answer questions in the coming weeks. In fact, sometimes the best thing to say is, look, I know you're going to have a lot of questions. I know you're going to have a lot of things you want to say. I'm happy to answer those, but sometimes it's better if people take some time, collect their thoughts, and then come back to me with those questions at a later time. Sometimes it can be an effective way to communicate that to folks. All right, and with that, I will turn it over to Anthony to talk about some additional legal risk issues.
Thanks, Eric, and thanks for everything that you said so far, which we'll cover a little bit more, some of the legal issues. But first, to kind of go through the rest of the best practices, you've decided what type of RIF you want to do. You've done your adverse impact analysis. You've come up with a strategy on how it's going to be communicated. But when does that need to be communicated? That's the next issue that we want to discuss, because depending on the number of employees you have or which state you are in, there might be advance notice requirements depending on how many folks may be impacted by the RIF decision. Federal WARN Act requires employers with 100 or more employees to provide the employees, any collective bargaining representatives, and local government officials with 60 days advance notice of a mass layoff or a plant closing at a single site. These have very specific meanings under WARN. Mass layoff is an employment loss of at least a third of full-time employees and a minimum of 50 employees at a single site. Plant closings can be different. Those are permanent or temporary shutdowns of a single site resulting in an employment loss of at least 50 employees. And then employment loss itself isn't just termination. It can be a layoff of at least 6 months, or simply a reduction of work hours of over 50% within a 6-month period. So federal WARN is the first thing to give consideration to when you're thinking about how far out in advance do I need to notify my employees, my affected employees, of the termination decisions. But in some jurisdictions, there are some additional requirements. 16 different states have their own mini WARN laws. These will apply to employers who may not be subject to federal WARN, or they may contain more requirements than WARN requires, or it could be a combination of both. And these states are all across the country. I won't go into what each one does is different, but generally speaking, they either increase the decrease the employee threshold to maybe 75 employees, 50 employees, increase the number of days out that notice needs to be provided 90 days, require the payment of wages or benefits for a certain period of time. Most of these laws are mandatory in terms of their notice provisions. Some are voluntary. For instance, Maryland it's more of an encouragement or a best practice than it is a requirement to follow its regulations. But even if no notice laws apply, advance notice always helps to minimize your exposure to legal claims and can impact, minimize the impact that a RIF might have on employee morale and productivity. So certainly the more notice you can provide, the better. It allows employees to understand what their next move is going to be, digest what is happening, and the more time you give for that decision, the less risk you may have to facing a lawsuit at the end of the day. And in addition to notice, some other considerations to have is what type of severance plan will we provide if we provide a severance plan. If we're going to tie a RIF, either involuntary or voluntary, to a severance offer, there are a number of considerations to have. Do you ask for a release of claims in exchange for providing severance benefits? If you are going to provide severance benefits, what types of benefits are you going to offer? Typically, it's a lump sum payment. It could be small or large. It could be a flat number. Maybe it's tied to a certain number of years of work or months at the employee's wage. Are you going to pay accrued, unused vacation? Are you going to pay unaccrued paid time off? Will you cover the employee share of COBRA? There are a number of different benefits that can be offered as part of this severance. Another thing to consider is whether the severance or the provision of severance will be subject to an ERISA-governed severance plan. I won't go into that much, but just know if it will, then creating that plan, an ERISA plan, will spell out the eligibility requirements for severance in the process by which that plan needs to be administered. Certainly, if an offer of severance is being made, contact your employee benefits attorneys and make sure that you understand what laws you may need to navigate from that perspective. We certainly encourage employers who implement RIFs to consider securing releases of exchange in exchange for severance. Certainly doing so, again, helps to minimize the risk of lawsuits. If employees are releasing their claims, that's less legal exposure and employer risks at the end of the day seeing. Are there situations where releases shouldn't be required? That's kind of an employer by employer decision. Are the severance benefits that are being offered insignificant? Is it really enough of a carrot to incentivize somebody to release any claims they may have against the company, or even that they may not have, but to sign that agreement and give you as the employer that peace of mind? If the employee is only being paid severance benefits that have already been promised through company policy, that may affect whether you want to ask for a written release of claims, as we'll see when we talk about the ADEA here in a second. Especially with employees over the age of 40, there needs to be additional consideration beyond what they're already entitled to. But that also goes to really employees of all ages. Severance agreements are contracts. Contracts need to be supported by consideration. If somebody's already entitled to something, there is a risk of want of consideration with that. So, if you're not going to be providing anything other than what they're already entitled to, is a release agreement necessary. Some employers also look at whether they want to avoid providing OWBPA disclosures. We'll talk about that in a minute, but with group terminations involving employees over the age of 40, employers need to provide certain levels of information relating to who was eligible for selection, the positions of the employees who were eligible for selection as part of the group separation, and the ages of those employees. And some employers believe that That's just, we're providing more information that could be used against us by a plaintiff's attorney. Why would we want to do that? So these are some considerations that employers have if they're deciding not to ask for a release in exchange for severance. But turning to the OWBPA, stands for the Older Workers Benefit Protection Act. This is an amendment to the ADEA that provides some additional protections for employees over the age of 40 in connection with release of claims and offers of severance. Mostly it's designed to provide additional information and to protect older workers and eliminate situations where they may be pressured into signing one-sided severance agreements. But these, on this slide, these requirements apply to any release agreement, necessary to release federal age claims, whether as part of a group separation or not. You need to specifically refer to rights and claims arising under the ADEA, advise the employee in writing that they have the right to consult an attorney before accepting the offer, provide the employee with 21 days in the case of an individual termination or 45 days in the case of a group separation to consider the agreement. The employee must also be provided with 7 days from the date they signed the agreement to revoke that acceptance, which can impact payment deadlines and the like. And also, as I mentioned before, be supported by additional consideration beyond that to which the employee is already entitled under state law or employer policy. Group separations come with some additional requirements, as I've already alluded to. There's additional information that needs to be provided. Typically, it's provided in an appendix to the separation agreement that provides the necessary disclosure information, but this includes information about eligibility factors for the employees who are participating in the group separation, the time limits for the program, the job titles and ages of all employees selected for separation, and those in the same job titles not selected for separation. So additional information needs provided there. And even after all that we've discussed, you've communicated the termination decision, you've decided whether to secure releases, it's important not to forget termination basics. When you're conducting a large reduction in force, that can be harrowing, it can be complicated. There's a lot of moving parts, as we've discussed, but there are always additional obligations that apply to all separations, RIF or not, that you want to make sure you're thinking about. What are the timing requirements in your jurisdiction for final paycheck laws? Some states require final paychecks be provided that same day, but every state has their own timing requirements for final paychecks. Are you paying out any unused PTO or vacation as that's dictated by your policies or state law? Some states do require that to be paid out as well. Administering COBRA notices, reminding employees of restricted covenant obligations. Are they bound by a non-compete? Have they been privy to confidential information? Providing them with written notice and reminder of these restrictive covenant obligations is important to remember. And at the same time, ensuring the return of company property. Does the employee have a work laptop, a work cell phone? Have they taken company property home to work on? Making sure that there are reminders in place and procedures in place for collecting that information back from separated employees is certainly important. And also providing applicable unemployment rights notices, responding to inquiries from state unemployment offices. It's usually good to have one point person or point people or some procedure in place for responding to these inquiries to ensure, if multiple people are being separated as part of a RIF, that the responses to various state agencies are consistent. And Eric's kind of talked about this a bit, but what happens when you do get sued? How do these types of cases work? It's all going to hinge on whether or not it's considered a RIF under the legal definition or not. And as you recall Eric saying, A RIF is a permanent elimination. It's not a temporary elimination. It's also not a replacement. So a typical employment or discrimination case, in all employment discrimination cases, there's a kind of a back and forth game of tennis, if you will. The plaintiff has the burden to establish a prima facie case discrimination, which is a very low threshold in most cases. Once they meet, and that revolves, they're a member of a protected class, they were qualified for the position they held, they were subject to an adverse employment action, and they were replaced by someone outside of their protected class. Is typically in separation cases the prima facie case that's applied. Then the employer presents their legitimate non-discriminatory reason for the separation, and then the employee has the final burden to try and show that that reason is not the true reason and it's pretext for discriminatory motive. That changes slightly in RIF cases. In a RIF situation, the replacement element, it's not there because it shouldn't exist. An employee is not being replaced, their position's being permanently eliminated. And so in a true RIF, a plaintiff has to show, in addition to being a member of a protected class, qualification for the job and subject to an adverse employment action, they have to show additional direct, circumstantial, or statistical evidence tending to indicate that the employer singled out the plaintiff for discharge for impermissible reasons. And that's a high burden to meet, and courts recognize that that's a high burden to meet. But it's only a burden that is available and that an employee is required to establish in a RIF case. We've seen cases, and there are plenty of cases out there where an employee is let go, but their job duties are absorbed by somebody else in the department or maybe spread out across a few people in the department. And courts won't apply this type of test to those types of cases. It's got to be a permanent elimination type of case for this to apply. But when it does, there's quite a bit that the employee needs to show. Qualifications superior to those of similarly situated coworkers outside of the protected class, like Eric mentioned earlier with his example. What does similarly situated mean? Do the employees have the same supervisor? Have they been subject to the same employment standards? Have they engaged in the same or similar conduct without any distinguishing or mitigating effect or nature? Employees can also show statistical disparity in demographics of the selected employees or statements indicative of discriminatory motive. I think the classic example is, we've all heard of it, but a company that wants to inject youth into the organization could be an example of direct comment evidencing discriminatory motive. But evidence of that other employees outside the protected class retain their jobs is not sufficient to establish the prima facie case. But if the plaintiff can, we then have the burden to show that the selection was based on non-discriminatory factors. And it bears repeating everything that Eric mentioned at the beginning. This is going to come down to how well the RIF process has been documented. Are the reasons warranting the RIF documented? Has the employer developed uniform selection criteria that identifying what that criteria is? Is it in writing? Has it been determined before it's been applied? Are there documents listing employees in positions subject to consideration for the RIF and how they rank against the criteria identified? Are there spreadsheets? Are there any other documents that show a concerted effort to fully consider the effect of the RIF before its implementation? Is there evidence of conducting an adverse impact analysis? Is it subject to privilege? Is it not? Do you want to consider waiving privilege in the event it was performed subject to privilege? At the end of the day, the employer has the burden not only to show that they have a legitimate non-discriminatory reason for the separation, but you want to make sure there's enough evidence to stave off any claim of pretext, because the employee will certainly poke holes in that legitimate reason. And if there's evidence out there, that raises a question, could a jury go either way on this? then you're facing trial, and you're facing the uncertainties of trial and the cost associated with trial. And so the more upfront work that's done to document the RIF process, the more insulation an employer has against the risks of trial, and the greater the likelihood of success there is at summary judgment. Just finally, key takeaways. I think the one thing that's not on here that probably should be is call your counsel, either in-house or outside counsel. Understand the implications. I know it's implied in everything that we do, but it's worth saying again, especially since this is the last slide of the entire presentation. But make sure that legal counsel is involved. But determine the basis for the RIF, write it down, ask tough questions, make sure that we have a clear idea of why a RIF is needed as opposed to one of the other options. Determine the selection criteria before decisions are made. Review the decisions, review the disparate impact analysis. Determine how and when you will or need to provide notice. What benefits are you going to provide to those being selected for separation? How are you going to handle the termination communication? And most importantly, document the process from start to finish. And so I thank everyone for their time. And Eric and I both thank you for sticking with us for this presentation. I've got the CLE tracking code up on the screen. It is TH128W. Again, TH128W. And thank you.
Thanks, Anthony, and thanks to everybody who attended today. We're going to be sending out today's recorded session in the next 1 to 2 business days, so be looking for those materials to arrive in your email soon. For those who were participating in the webinar and are seeking CLE credit, I'm going to repeat for you those CLE credits for your affirmation form. So segment 1, which was 9 to 10:15 a.m., the tracking code is TH128C. Segment 2, which was 10:15 to 11, that tracking code is TH128E. Segment 3, 11:15 to 12, tracking code TH128B as in boy. Segment 4, 12:45 to 1:15, tracking code TH128U. Segment 5, 1:15 to 2:15 p.m., tracking code TH128D as in dog. Segment 6, 2:15 to 3, as Anthony just said, TH128W. If you had any questions that we were not able to answer today or get to, please email or call your regular Thompson Hine lawyer. If you are not a current Thompson Hine client, please contact any one of us and we can help you get your legal needs assessed. Thank you to our presenters and for everyone who attended today. We hope and wish you all a safe and happy, healthy end of the year. So that's wrapping it up for today.